ये मीटिंग YouTube को भी है दादी लाइव तो भी थी
Yes. Why do you want hearing?
Not hearing.
IS. When do you want?
Tomorrow.
Tomorrow. What? Vision. Day after. Day after. Day after. Yes. What is memo that we can make out from here without you saying anything? Day after. Day after. Day after. What is the urgency? What admission? For admission? Monday. Monday.
Private number 1. Amsuman here. Number 2. Srimati Ji. Sharda Bhai.
May I request the court to kindly peruse the order sheet dated 11/11/2021.
What is office objection, IA urgent hearing, rectification of office memo? This we have to fix a date, right? Early hearing at the most.
No, this was substantially heard on 11/11, of course, in a different combination. I should admit that was in it. And after hearing, the court was pleased to direct production of the minutes of the meeting on 11/11. That is all what is required to be shown. And
yes, memo. You have 5 minutes of meeting. He has 5 minutes. You speak into the mic. We don't want to be your spokesperson to him. This is a very peculiar situation. He will say, I am unable to hear. You are speaking this thing. Speak into the mic so that he can hear.
Since the date wasn't fixed, the fine was released. The date will fix not the any time after 10.
He says that date may be fixed. You have to produce the minutes.
Because I have produced draft with the memo.
I am ready. Matter may be heard any day convenient to the court this week or next week.
After 10th.
After 10th, that will be too long a day. That will be too long a day.
But this is 2019 appeal. We are dealing with MFAs of. You will be pleasantly surprised to know that we are dealing with MFAs of 2011. And we have to convince the council to argue. In that case, also they are seeking adjournment, Mr. Varma. So this is, we will fix a date after.
Could it be sometime next week? Any day next week?
12th April 2020. Heard on IA number so-and-so an application for early hearing or after hearing so-and-so is allowed list on 12th April.
Please.
Number 3. MC Basuraja. CBS Sanjay. CBJ Somaya.
Joint memo of complainant. What? Why this has come contempt? Connected with the appeal may. Let's try and step. Oh, learned counsel for the mark the presence. Learned counsel for the parties have invited the attention to the governments contained in the joint memo and have pointed out that the parties have arrived at a mutual settlement with regard to their differences on following terms. 1, 2, 3, 4.
What about accused number 1? Accused number 1
Accused number 1 deleted long back.
is deleted, is it?
Deleted long back. In the court list itself is mentioned.
Of the amicable settlement arrived at between the parties, we are not inclined further proceed with the proceeding. This proceeding accordingly same is dropped. Contempt is dropped. Writ appeal is also same. This is appeal. Next is 3.1.
What should happen to writ appeal?
Same terms,
Writ appeal.
same. It's not the counsel for the 3.1 appellant seeks leave of for the appeal. In view of amicable settlement arrived at in view of this settlement arrived at between the parties. Accordingly, the appellant
Moving a memo.
memo. Okay, this is item number 4. We thought you are appearing in item number 4 and telling us that you have settled and you want to withdraw. Want to withdraw? If you tell us no, that I want to make a memo mention, we thought that in item number 4 you are what? Sorry. 2 weeks.
Number 4, register offer. Number 5, non-litigation.
2 weeks.
Appearing for the appellant in this matter, Lordship may give me 2 weeks time to comply with the office of civil standards. Serial number 6.
Number 8, documented. Number 9, non-litigation. Number 10, private. 11, Murtiya. Number 12, Shweta. 13,
2 weeks.
Number 14, Nita Ramkrishna.
2 weeks.
Number 15, D. Pramod.
Petitioner Mash, 2 weeks.
Mahadevi Ahmed. 17, A. Sudarshan.
2 weeks.
18, C. A.
Weeks time.
Number 19, C. Subareddy K. Government Advocate.
One objection is there. With respect to translated copy of the.
Who is missing your
Why? Daughter of the.
daughter? Oh, she must have married right away. What's her age?
21.
Ah, so
That's not there. One
be ready to welcome your son-in-law in the family in this property.
the issue is not-
You know, right? You know she is married.
There is one apprehension.
Apprehension, what you know it.
The.
Perhaps, I mean, you should know it beforehand. Why you should know one minute. If you know beforehand that your daughter is married, why should you file the CPS corpus and seek a declaration here from her mouth? She will appear along with her husband and mark sheet and everything. And she will say that she will tell us that her husband is a film producer.
And you're going to kill her.
And you are going to kill her. So she doesn't want to see you because you are issuing threats to life threatening messages you are sending. So that's what she's going to tell us. We have done some research on this. Our intuitive skills have been really sharpened on this. So that's why we are telling you all this. What will happen in future? They may also move a memo saying that police is harassing them. So they will be ready to appear on a short notice and hear all this. You remember on that day that we had told you this, right? Notice. Undertakes to comply with office objections within 1 week. Notice on behalf of. Hey, where is that person?
You have not made him as a party.
Where is that person in whose custody your daughter is?
This person has been missing from 5 days ago. The other person who is he's on bail,
No, but you have to implead him, right? If you are saying that your daughter is in the custody of somebody else, so you have to implead him.
I'll There is a criminal case registered against him also way back in 2016.
No.
That also is that FIR is also I don't know, that matter is in the stage of evidence.
No, you have to implead him as a
Silently.
undertakes to implead the person in whose custody, alleged illegal custody, the daughter of the petitioner, who has been taken into illegal custody, who has taken the daughter of petitioner into illegal custody. Implead the person who has taken so and so illegal custody. then notice is accepted by SPP or HG, what you who are you, HG, whatever. Praise for it is granted. He is trying to enable him to seek instruction. Find out. She herself will contact you.
But Jagdish Murthy came, government advocate.
Being brought by the police. And
Oh,
was left
today. So then, okay, so why?
petitioner. Mother. There are on 26.
No, we don't require her presence. Detainee means the person who has been detained.
He was detained. I would like to produce some video footage when he was taken out from the house. At 2 hours 40 minutes early in the morning, 6 policemen barged into the house, my lordship. 6 persons barged into the house. He is nowhere concerned to that particular place.
But he is here, right? Ganga Raju is before us.
Yes, my lord. And video footage, he was
Whatever, file a petition, do whatever he, this is habeas corpus. When your client is in, then you should not have filed the habeas corpus thing when he was in.
No. Yesterday he filed it, and today morning, 6 o'clock, they have got him and left him.
What is the effect of serving an advance copy on the state? How promptly it acts?
But
We wish that in every case you do it.
The apprehension now, my lord, is several signatures have been taken by. Now it's what is also coming
No,
forth
but
is
we'll understand.
It is
that
the-
you will have to take action.
it is the Andhra Pradesh police who have come along with the local police. From state corporal police people. They had kept him in detention for 5 nights and 4 days.
Why was he taken? What offense?
Do take action. Habeas corpus. Current counsel for the petition. This petition has been filed seeking a rate of habeas corpus against the habeas corpus to the respondents to trace and produce the detainee Sri Ganga Raju B before this court. Paragraph when the matter was taken up today, learned counsel for the petitioner submitted that after filing of the petition today morning at 6 a.m. Sri Ganga Raju has been released. The detainee Sri Ganga Raju has been released by the respondents. Full stop. It is also stated who is present in the court. It is also stated that he was kept in illegal custody by respondents for a period of 5 nights and 4 days.
4 days.
5 nights and 4 days. Full stop. In paragraph, in view of the fact that the
Documents have been filed by him on
in view of the fact that detainee is present before this court, nothing survives for adjudication in this petition. However, the liberty is reserved to the petitioner to take action against the respondents if so advised with regard to his alleged illegal detention. With the aforesaid liberty. On compliance, 2 weeks.
Number 22, Atul Tiago.
Permission of the second section of morning operation. Already we
So, second set has been filed. Objection is therefore complied.
148 issue where is the new provision on individual but identical issue is
No,
their rights have been challenged.
Arey, Mr. This is 21, right? 22. That's the problem. We are taking up 21 years for 21. We are saying MFA, GW, how 148 arises, we are wondering. 21 over. How much time? 2 weeks. 22. Current counsel submits that so and so he has filed the second set of repetition. 148, you know that order, right? This was analogous hearing along with what further proceeding pursuance of notice dated 3421 shall remain state till next date of paying. Notice is accepted by Mr. In the beginning itself. Mr. Get it tagged. We are getting every day.
18th. All other matters are on
18th. This on 18th April. Get ready, Mr. We are every day 3, 4 adding up. And they say that it's all covered by 6, 7 high court. We don't know. We haven't examined. Take an initiative, get the petition so that we can prevent the inflow of litigation to this court. Yes.
Hearing the highest. Number 23.
I appear for the petitioner in this case, my lord.
What is the amendment?
I have filed the second set amendment. Additional grounds I have sought for amendment.
Yes, madam, you are appealing. So what do you say with regard to amendment? Additional grounds, any objection? Learned counsel for the petitioner submits that he has filed the second set of petition. In view of opposite submission of his objection is ignored. Heard on IA 1 of 2019, taking into account the nature of proposed amendment for the reasons stated. Same is allowed. Late amendment of the petition be filed within 1 week.
Much obliged.
One submission, Your Lordship. Amended copy might be given to the respondents, Your Lordship.
Serial number?
Yeah.
18. What has happened? 18 adjourned? No. 18.
That is the 18 is
Apply with office
that
of.
girl is. And you should have told.
Where is the counsel? Call
Bring
him.
him. Yes, yes.
Please get him.
Get him.
Please. Oh, he's see what he's lucky that he's getting the news about his son-in-law today itself. Yes. Call him.
24. Ismail Zabiullah. Sanjay Kumar.
Mr. Supply a copy of amended petition, right? You right?
I am for the respondent in this matter.
Amended copy of the petition be supplied to respondent. The same be filed within 1 week. Yes. Respondent.
Number 24.
Not on IA 1 of 2019, take 18. Delay control IA is allowed. 1 or 2 of 18 shall be considered at the time of hearing of the appeal.
My lord, I am for the respondent in this matter, my lord. Arrest warrant has been issued by the trial court. In spite of the arrest warrant, he has not joining with the wife for a period of 12 years.
What have you done? Why arrest warrant has been issued?
My lord, he is not joining with the wife. In spite, there is a decree has been passed by the trial court in the year 2018. And the wife is crying, the child is also crying for the father. Father is residing at Hyderabad, is not turning up, and in spite the continuous notice has been issued by the trial court, my lord.
We don't know. This is MFA, and this is for condonation of delay and IA. We do not know what trial court has issued non-bailable warrant. There's no this is not the subject matter. Should we tell you against which order this appeal has been filed, or you know?
Yes, my lord. It is against the order of decree for restitution of conjugal rights. The appeal has been filed by the.
Fine. So why it is listed today?
My lord, they have moved a memo for staying the order. The petitioner who moved the memo before my lordship, my lord. I am for the respondent.
It is listed. You don't know, right? Thank you. Find out. We have passed the order. Whatever you find out why it is listed today, what orders have been passed, everything you find out later on at your leisure whenever you get time. Thank you.
25.
Ignorance is real bliss, Mr. Really, it's bliss. You are in a blissful state. We have 83 days delay and don't die is allowed. Seeks leave of this court as filed the memo seeking leave of this court to withdraw. May stay.
36.
Delay 1 or 2 delay controlled by is allowed. Admitted for it is admitted.
Matrimonial, not
I will,
matrimonial.
this is SFC.
Number 27, Sri T. Nataraju, M.Y. Srinivasan.
Delay control, IA is allowed. Admitted for hearing record.
Number 28, Sri Sharavana S. Sri T. N. Rajeshwari, Government Advocate.
Not for petition number 1 to 3.
Yes,
for respondents, madam.
Kumar Sundar.
Yes, madam. Yes, for respondents.
He has to rectify some conflict of interest, madam. He is in the VC, madam.
Yes.
Sri Sharavana S.
Not the petitioner 4 to 6 minutes, and ourselves will comply the office submission. There are series of office submission. We both shall comply with the office submission notes.
Rajeshwar Rao. Rajeshwar. Learned counsel undertakes to comply with office objections within 1 week.
Please, no.
1 week.
Number 29, Sri N.K. Ramesh, Sri Abhishek Malupati.
With regard to finding of the review alert, I have already apprised that. Unfortunately for me,
April. This one. 8th of April. This one is marked. And counsel for the appellate raised for adjournment. This on 8th April. We can allow it. We are hearing you. That means what is it? Because we permit implement, we already seeing the queue outside. The students, instead of studying, they are roaming in the court premises. We don't know how does it. The student who is using this course in Ayurvedic medicine, how does it help? How is it by the environment in the court? The writer will know nothing. Right. But we are just saying. We'll deal with it on the, we'll allow it. We are hearing you. We have entertained your application. What is it? It's only a formality. Please argue. Ramesh, argue on that.
Number 30, Sri Suyog Kherde.
Your Lordship, Senior Counsel. Your Lordship, in this matter 30, Senior Counsel Sushil Kumar Jain has been engaged. He is on his legs in another court. Please pass over the matter.
Take into the mic.
Sorry, Your Lordship. Senior Counsel Sushil Kumar Jain has been engaged in this matter. He is on his legs in another court. So please pass over the matter.
Sir, counsel for petitioner is seeking adjournment.
Counsel for petitioner is appellant is seeking adjournment, madam.
Not adjournment, only pass over for some matter.
Advocate for the appellant, he has got some inconvenience.
Why? Madam, tell her that she is paying for 5th April. Tell her.
Madam, counsel for appellant is praying for 5th April, madam.
5th April. Obliged, sure.
Hey, oh, all right. Mark the presence. What's your name?
Shruti Singh.
Any counsel for respondent submits that the matter has to be argued by Mr. Sushil Kumar Jain.
Senior advocate.
Fine, we understand, madam. It needs no emphasis. We have in our Bangalore, we have 80 senior advocates. So it's not that.
No, Your Lordship.
Sushil Kumar Jain is the only senior counsel in the country. It's
no,
not
Your
like
Lordship,
that.
I apologize.
Thrice you have emphasized. Thrice senior counsel, senior. So what is so special? What is so special about senior counsel? So you want to tell us that we don't know anything about senior counsel, right?
No, Your Lordship, I apologize.
No,
I only
be
want
within your limits, madam. In our court, we don't this thing. Appreciate this sort of this thing. Thrice you have told us. These senior advocates. What senior advocate? For us, every advocate who has put in even a 5 days practice is equal. What is this? Thrice you have told us merely for seeking a password. You want to emphasize that he is appearing, and that message should be conveyed to us, right?
No, Your Lordship.
That's it. No, we understand, madam. You are too young for playing these pranks with us, right?
Your
Too
Lordship,
young.
I just thought I'm not clear enough, so I just
No. Thrice you have told. Thrice you have told the name of senior counsel. You want to tell us that I know him. I know him since my practice days. That's what you want to convey, right, madam? By taking his name for thrice. Don't be over smart. You are too young for playing these pranks. And I have known him since when you are not even born, right? So we understand. We can read between the lines. Don't do like this again. Be within your limits.
I apologize, Your Lordship.
Praise for adjournment. Just on 5th of April 2021, interim order granted on earlier occasions shall continue. Then praise for adjournment on the ground that the arguing counsel is not available. Then she says has to be argued by senior counsel. List on 5th April.
Much obliged.
Yes. Yes, madam. One minute. Yes. Mr. What this is some default something, right? Morning. And dispensation, what certified copy? Now what is to be done?
On the previous date of hearing, my lord has granted an interim order not to take any coercive action against it.
Respondent number 1 and 5, connected matter. So for respondent number 1, the RBI, we've just filed a wakalat in the counter today. Request for 2 weeks time to file a statement of objection.
Statement of objection. All right.
As regards the
31, learned counsel for the appellate petitioner undertakes that the deficit court fee of rupees 240 has been paid by the appellant to date, sir. Heard on IA 1 of 22, an application for dispensation of production with certified copy of the order for the reasons assigned in the application, same is allowed. Then 31.1, you appear. All right. Mark her presence. What's your name, madam? Tell her. Learned counsel for the petitioner. What's your name, madam? Learned counsel for respondent number 1 submits that she has filed wakalat on behalf of respondent number 1 today. She prays for and is granted 2 weeks time. 2 weeks time to enable her to file connected matters also. Statement of objections. Connected also 31.1 dispensation and all that is there. Whatever pending IA.
one more submission. As regards repetition 522 number 30. My client is instructed to accept notice on behalf of respondent number 1.
All right. So then 31. Write her name. Learned counsel accepts notice on behalf of respondent number 1. Office is directed to reflect her name. Right.
Interim orders may be extended.
Interim order shall continue till next day. Both. 31.1 also.
32. Government educate.
What is dispensation?
Dispensation for production of the original.
What is it?
My lord, annexure D, the originals of the rules.
So that this thing 32 IA 1 of dispensation is allowed. Is it covered? What?
My lord, this matter is challenging the amendments that was born to the Karnataka Municipal.
Karnataka Minor Mineral Concession Amendment Rules.
Yes, please, my lord. The matter is covered by the judgment of this honorable court.
Covered? Yes, madam.
Not covered by the judgment of this
All
honorable
right,
court.
learned counsel for the petitioner. Where is which judgment? Learned counsel for the petitioner submits. Oh, so entire rule has been struck down.
No, my lord, it's been
What
passed.
rule?
The Karnataka Municipal concession was various provisions were challenged, my
No,
lord.
but you have not said anything.
Lord, this matter has been taken on an SLP now to the Honorable Supreme Court. And the Supreme Court has asked for the interim order that was granted by this Honorable Court to be operating. And this order is stayed. I should pass on the orders of the Honorable
Which order? This order?
Yes, Lord, it's been stayed by the Honorable Supreme Court.
Then why should you file a petition here? You should wait for. High Court shall be extended. Oh. Yes, madam. In this petition, she has filed the writ petition only for an interim order. What is the interim order?
Lord, the working permission has been allowed.
Working permission.
Yes, Lord.
Do you examine it? We'll take it tomorrow or day after, madam.
Lord, can I request for Friday, my Lord?
Friday, yes, Friday. You just see, she has given this. She says it's covered. This judgment, you have to go through this, and then against this SLP has been filed. That has been entertained, and it has been said that interim order granted by the High Court shall continue, right? So you have to just ascertain this. If it is so, then she is also they are entitled. It's provided in this petition, petitioner has said the validity of Karnataka minor mineral within bracket amendment rules 2016. Learned counsel for the petition submitted that the aforesaid rules have already been struck down. Right, madam? Struck down. It is further submitted that it is submitted by learned counsel for the petitioner that validity of aforesaid rules was under challenge in a batch of writ petitions, and the writ petition and the writ petitions have been partly allowed. In support of aforesaid submission, reference has been made to judgment dated 1st of June 2020, passed in WP number 58505 part 2016 and other connected matters. It is also pointed out that against the aforesaid order, a special leave petition has been preferred, namely SLP number 773-788 bar 2021, in which has been entertained, and by an order dated 27 January 2021, it has been directed that interim orders passed by this court has been extended until further orders. Full stop. In view of aforesaid, learned counsel for the petitioner prays for an interim order in terms of the order already granted by division bench of this court in the said writ petitions. The paragraph in view of aforesaid submission, learned additional government advocate prays for short accommodation list on Friday. Friday is what? 1st of April.
Number 33, the postgraduate.
What
in this matter, I appear for respond number 1, my lords. I have entered appearance
judgment, right?
17-2. Yes, I have to file objections to the petition, my lords. I seek for 3 weeks time to file objections.
How sitting in his office he can this thing
lords,
predict what you are going to do. See how he comes to your rescue. How much time, Mr. Kumar?
3 weeks time is required, my lords.
3 weeks time.
3 weeks
That's
time
what he
is
wants.
Last month only, yes.
What he wants, right, Mr. Mark the Perez, Mr. Kumar, learned counsel for Central.
Respond number 1, my lords.
1. Praise Fund is granted 3 weeks time to enable him to file statement of objections.
Objection. Oblige, my lords.
Good.
Appear for the second respondent, Your Lordship.
Yes. Yes, madam.
The matter may be heard, Your Lordship.
Huh?
The matter may kindly be heard because I've also filed an application for vacation of
For
stay.
vacating stay. Yes.
Petitioners have been taking time.
1 week time. Why?
Repeated
Speak into the mic.
My senior counsel suffering from neural.
So, madam, do you have an answer to this?
I leave it to the Honorable Court.
What can we do? I mean, we have to rely on his statement. We can't, I mean, so viral fever. Huh?
A date may kindly be fixed, a short date.
What is the matter, Mr.? You tell us. You tell us at least something about the case. What is it about? We will pray for a speedy recovery of your senior, but you at least tell us what is the case about. Something, what have you challenged? What is it about? Is it so difficult, mister? You don't have file. Acha, you remove the mask. Please tell us. My brother, this thing, he realized that probably you have mask, you may not be able to speak. Please now tell us what is the matter about it. Huh?
I'm not ready to know.
Not ready? No. We are not asking you to argue, but tell us at least what is the writ petition about? What have you challenged? Of what? So, the counsel, this is not good. I mean, there's nothing to smile. We are smiling. Therefore, you should go through the files at least. How do you come? Why are you so confident that the court will adjourn? Supposing if we say that no adjournment, then what happens to your client? And it is being live streamed. Your performance is being live streamed. And supposing by mistake, if your client watches the proceeding, what will happen to your future? It's all these are the questions which will arise in this thing during a period of time, right? So all being live streamed, your performance is being watched by everybody. No, you should be, I mean, at least you should go through. Don't be under the impression that always the court will adjourn. Supposing if she would have opposed the prayer and we would have not granted you adjournment, what would have happened to your client? So when will, yes, madam, when? Next week?
Yes, Your Lordship. One submission.
6th April. 6th April.
Grateful, Your Lordship. Just one submission, Your Lordship. The same relief has been sought by the same institution in one more writ petition for the subsequent year. May I request that that matter be connected and both matters may be listed together?
Which is the petition?
WP 14106 of 2020. 14106.
2020.
Yes, Your Lordship.
The counsel for the petitioner prays for adjournment on the ground that the arguing counsel is unwell. The counsel for respondent is appearing for one matter.
Second respondent, Your
Respondent number 2 submits
yes,
that this petition be heard analogously along with WP number so and so. In view of a forces submission list for analogous hearing along with WP number so and so.
Grateful, Your Lordship.
Lord, I appear for the respondent, my Lord.
Yes.
My Lord, I'm sorry, my Lord. This is unfortunate, my Lord. You do not have I do not have the copy of the appeal and the order copy. Otherwise, I know the facts of the case, but I do not have that order judgment because they have not served us. So I am extremely sorry, my Lord.
No, it's all right.
The situation
if you
is
are praying for an adjournment, it has to be granted, Mr. Rao. You are always ready. So this, yes, Mr. Ola, absolutely. Acha, in any case, I mean, it has to go before a different combination, right? Let mark the presence.
No,
Learned
Lord,
senior
they may be
counsel.
directed to serve a copy on us, my Lord.
Please supply.
I'll do that.
It will be supplied.
Very well.
This
Much
before a
obliged.
bench in which one of us write his lordship's name is not a member.
Already.
We are not doing anything, but yes.
36. Suprapal, yes. Sri Vamsi Krishna Singh. Permitted to take Sri Sailesh Shankar. Sri N. Nagarajappa.
Yes,
My Lord, I'm obtaining for appellate. As IA is concerned, it was imposed of in the last occasion, my Lord. Now it has to be asked finally.
It is for preliminary hearing. Yes. Yes. There is a stay, right, in your favor?
No, there is no stay.
No stay. All right. So, yes, what do you say?
My Lord, see, it is in regard to.
No, government advocate has made a prayer for adjournment. In that context, we are asking you. If you are opposing, then we will hear it, whatever. He says
I
that.
leave it to this honorable court, my Lord, ultimately.
It's very difficult choice. Huh?
That is
What
the
leave it?
discretionary power of the
No,
court, my
what
Lord,
discretionary power? Hey, wait. Yes. So, when do you want, madam? Huh? Immediately after vacation? Fine.
And it is regarding disqualification of a membership. Since 1 year, she is not working as member. So on untenable grounds, she was disqualified by the deputy commissioner. That is why next week, my lord, next week.
How many cases next week? Only 16, 15 days are listed. We can fix it provided we get time.
My lord, in a democracy, see,
there are many more
elected member, his rights has to be protected, my lord. That is my.
No, that's fine. It has to be protected. That's why we are adjudicating. But the rights of those litigants who are in before this court since 2011, they have also to be protected, right? Yesterday only we decided 2011 appeals pending before this court. So this is 21 only. We understand that it requires an adjudication because it will time.
In fact, last occasion, they were agreed. They were agreed for final hearing.
24th May.
Was urgent to today.
24th May. Mark the presence, learned additional government advocate prays for accommodation list on 24th May 2020
Finally,
for final hearing. Yes, we are saying.
Number 37.
Dispensation. Huh? Huh?
Praying for time.
Praying for time.
2021 they have filed appeal. Last week they have contacted the office of Municipal. They are trying to track the matter as long as possible.
Oh.
So 19 years delay is there.
17 years, not 19. 17 years.
delay.
My senior counsel is not well, my lord.
Not well. What happened? Viral fever? See, we know everything, madam. Your senior told us in the evening by calling us that I am suffering from viral fever. That's how we know. Otherwise, how do we know? How do we know? See,
My land friend is appearing to quota number 22 by morning. She is also appearing WP number 1621. It's a counter case.
Great. A serious matter, madam. Huh? Your senior is appearing. Who is the senior? Oh.
No, my senior is Sridhar, my lord.
He's
Son is
appearing,
handling
right?
this.
That's what he's telling
His
us.
son is handling this. I don't know about whether he's attending or not.
No, but you said that viral fever, right? So if
He is
he
not well, my lord. That's what I know.
Senior is not
Really?
well. Kishan is very well.
I know Kishan, but he is handling this appeal, my lord.
And the date will be 6 months.
Ah,
Can you have it on 5th, 4th,
So
or
when,
5th month?
yes, madam, when do you want? Tell us. Where do you want? When? The delay of 17 years will not be reduced in 2 weeks to 1 year, right? It will remain. We have read it. You also know it. You also know it. What will be the fate? What is the law? So just filing an appeal, trying to keep it this thing pending for one petition doesn't help, right? So argue it. We don't think he will remain ill for such a long time. The clients give vitamins, right? So advocate, is rejuvenated by evening he will be all right. So what's your name? And what's your senior's name? So and so states that our going counsel, Mr. Who is not well?
My senior counsel,
What?
Kisan. Kisan is not well.
Not well. Good stop. She therefore prays for adjournment. List on 6th April. Please ask him to. IA is discussed. IA allowed. Prays for adjournment.
38.
If
Government advocate.
Yes.
pay for the petition in 38.1 minute.
What is it, Mr.?
This is a case where the writ petition has been filed in public interest.
Right. So yes, ready, madam. We'll hear just motion hearing. Few motion hearing cases will finish and then take up.
Please.
These addition matters are there.
We think is not there's one part. Somebody is coming from outside. This woman, I don't want your nurses to wait.
So then which day?
Immediate convenient, your nurses. I'm sorry.
Oh, it's all right. Yes, Mr. Holla prays for.
Yes, yes, any date coming to the Leonard, my Leonard friend.
6th April.
Please, Your Worships.
All right, Mr. Uday Holla and senior counsel for the petitioner prays for short accommodation list on 6th of April 2020.
The office may be directed to show my colleague's name instead of my name.
Yes, office is directed to refresh. 38.9. Who is your colleague?
Lakshmi Hollam, Srimati Lakshmi Hollam. She is.
Instead of. Yes,
35. Interim order has to be extended. Subra Lord and
35.
Yes.
Interim order.
Yes.
Yes.
Number 39.
Oh.
Relief has been granted to all the petitioners.
Granted. Oh. See, we told you, Mr. We were right in our assessment that Mr. Ramesh is so considerate for students. So we always hear the counsel for petitioner after he speaks.
But what has happened, my lords, is
No. So relief has been granted, right? No.
Not exactly. Not
Not
exactly.
granted.
No, it has been granted, but to the extent, my lords,
No, just a minute. We'll take up your case a little later. Let us see. There may be other persons who may be satisfied. Yes. Madam, yes. Satisfied? Yes, madam. Next case.
That is not similar.
Acha, this is all right, all right. So we'll have to deal with this. What is, just a minute. Mop up round. So what have you, so what have you done? Yes. First petitioner is undergrad. Yes.
He wanted
Permission to appear in mop up.
Not permission.
To
Registration.
For
all students, fresh registration has been given. The notification is next.
It is not for mop-up round. Mop-up round of counseling is over. They are saying we are going to allow fresh registration only for the purpose of sending it for stray vacancy round. That's all. We're bringing to your lordship's notice that despite the fact that they should have allowed us for mop-up round of counseling.
This petition wanted only that has been.
Mop-up round is over. When?
Day before.
Yesterday.
Yesterday is 29th March.
This is what happens after mop-up round of counseling, where seats have remained vacant. For those seats, stray vacancy round at the institution level is now done.
So what can be done now, Mr. Mop-up round has been held.
No, that's all been admitted by a memo. What I placed on record.
How can we put the clock back?
That is all that I'm bringing to your lordship's notice, that this has happened. That's all. Taking note of that, Manoj may permit you to participate in the further round of counseling. It has become infructuous to that extent. I'm just bringing to your lordship's notice that they should have permitted us for mop-up round of counseling. They haven't permitted us. Mop-up round of counseling is over. The entire category of students are not permitted to participate in mop-up round of counseling. Entire mop-up round of counseling is over. Taking note of that, I may be permitted to further appear in the other round of counseling.
Yes, madam. Mr. Abhishek Madi Patil, learned counsel for the petitioner. Additional government advocate for respondents 1 and 2. Mr. N.K. Ramesh, learned counsel for respondent number 3. The petitioners in this petition, inter alia, have prayed for a direction. Inter alia have sought for a writ of mandamus, directing the respondent number 2 to 4. No, directing respondent number 3 to permit the petitioner to participate in the mop-up round as well as all further rounds of counseling of UG NEET 2021 and PG NEET 2021 paragraph. When the matter was taken up today, learned counsel for the petitioner submitted that the petitioners the petitioner number 1 seeks admission to undergraduate course in MBBS, whereas petitioners number 2 to 4 seek admission in postgraduate course in MBBS. It is MBBS, full stop. When the line below, when the matter was taken up today, learned counsel for the petitioner submitted that the mop-up round of counseling has already been held on 29th March 2021, and the petitioners were not permitted to appear in the mop-up round of counseling.
Only for petitioner 1.
Achha, petitioner number 1 was not permitted to appear in mop-up round of counseling. It is further submitted that grievance of the petitioners number 2, 3 and 4 stands redressed as they have been permitted to appear in the mop-up round of counseling, full stop. Therefore, the writ petition insofar as it pertains to petitioners number 2 to 4 have been rendered infructuous, full stop. The what you will permit petitioner number 1 to appear in subsequent round of counseling.
Not subsequent. Stray vacancy.
In view of Force's submission, Mr. N.K. Ramesh, learned counsel for respondent number 3, submits that the petitioner number 1 shall be permitted to appear against the stray vacancies which may be caused, full stop. Paragraph. In view of Force's submissions and taking into account the fact that the petitioner number 1 has also been permitted to appear in for counseling against any stray vacancies which may be caused
by the institution. At the institution level.
At the institution level, comma, the writ petition is disposed of. Yes.
Party. Government advocate.
Yes, Mr. Ramesh. Been permitted to appear in stray round of counseling, you have written, as well as petition, as well as the fact that petitioners 2 to 4 have been permitted to appear in the mop-up round of counseling. Yes. Yes. So what? Yes. What is it?
Those things may not happen. Things where those SC candidates have left the seats and gone to some other courses. So those vacant seats are being reserved for the very same candidate. We have not made any further seat candidates. Candidates who have taken the seats have vacated the seats and have gone to some other courses. Better option they've got in all India.
No, so why not in service? That's the question. That is what you do, but why? That's the explanation. That is there, but why it is so? That is what we had asked.
This is seat where they are unfilled. Total number of seats in this thing we got service results candidate. There are 400 seats now. Service candidate, and out of that 72 seats are being filled.
That's all right. That's all what we have written. But why we are doing it?
They were not, the percentage was not reduced. Those three seats have remained vacant.
So, seats were more.
You got our query right.
Yes,
We recorded
yes,
it in the order sheet.
Yes,
See, the submission is that for SC, ST category 1, 2A, 2B, 3A, everything is continuing. Why not in service category? Tell us.
To maintain the roster, 50% of the seats have.
No, but why? So, what is your explanation for not maintaining the roster for why in service? That's what is this thing. Why? That's the question. Why? That you told us yesterday, or we don't keep, and page 92 says so. That is what is questioned, right, in this petition. And that's what we had asked you yesterday. Mr. Ramesh, 1 minute, we'll hear you.
What will happen in the first round is there are more number of seats and less number of candidates. As far as interview seats concerned. In the first round, all candidates were exhausted.
More number of seats.
Yes. Here not for interview.
So how many candidates were there?
72 candidates have taken the seat.
Only 72.
Only 72.
And how many seats?
The remaining seats.
Oh, that is the reason, right?
That's the reason.
So, all right. So then,
Then what happened? Then what happened? Second round.
how many seats were reserved for in service?
496.
396.
396.
390.
Now, what has happened, Mr. Mop-up round is tomorrow? Mr. Ramesh, mop-up round tomorrow. First and second round held. First round where? Oh, right. 25th January and 25th February, right? Second round. 25th February. And you have become eligible on 12th March 2012.
Yes.
Fine. So now these seats, how many seats were vacant now?
No,
Madam? No, after filling up the first round. As on 26th January, how many seats? 324 seats. So these seats have been decategorized and they have been filled up in second round of counseling by general. What can be done, madam?
May not sit in.
At this point of time now.
No, my lord, because they become eligible, then only they can come before the
No.
honorable court. Because they have become
That's
eligible.
fine.
My lord, this is
We
not
have
a
understood.
question.
Please, we understand. We are just discussing.
Yes.
Not we are in a hurry to dismiss.
Yes.
We are just trying to understand.
Yes.
So see, now 396 seats were there.
Yes.
At that time, 72 candidates were eligible in first round. All of them, they got admission. Fine. 324 seats remained vacant. Right? 324 seats. Just listen to us. We are just, we will hear you. We are trying to understand. 324 seats remained vacant. Then, according to their instructions, all these 324 seats were decategorized. And in the second round of counseling on 25th February 2022, they were filled up by general category candidates. Right? Now you have become eligible thereafter on 12th of March because of cutoff by percentage by this exam body. You have become eligible on 12th of March. So therefore, the cause of action I have not accrued to you. But now on account of a fortuitous circumstance, like 12th March, nobody could anticipate that they would cut off, the cutoff mark would be reduced. Now those seats have been filled up as we get it. Those persons who have been admitted against your seats, in service category seats, are not before us, not parties. How can we disturb their admission at this point of time? Or you have to tell us that those seats are vacant.
My lords, they have not even published the number of seats even after the second round of counseling. What they have done is this, my lords. My submission before my lords is because of the special circumstance in that is happening, and every time after the first and second round of counseling, the NMC reduces the cutoff marks. It is not the first round, first time itself in the history. And they knew very well that it's going to, because hundreds of seats were vacant after the first round of counseling, even in the general pool also. Therefore, my lords, after discussion with the central government, they have reduced the number of seats, cutoff mark. And now, my lords, they could have waited for another 1 week. Even the Minister for Health and Family Welfare himself writes on us, 1st of February.
That communication, please understand, that communication, we are not the enforcement agency that some ministers writes a letter, you file a petition seeking mandamus. Go to them. Go to Mr. He go to him.
My lords, my submission is not that. My lords, my submission is when the
lighter vein, madam. Don't be so serious. Nothing serious about. Don't be. So that he's there. Go to him. We can't do anything. Yes.
My lords, I'm not asking for the enforcement. What I'm saying is the minister concerned for the department himself asked for reduction. Then who has done this decategorization? Who has taken the decision to do it?
Just a minute. So what is your submission that these seats are vacant where they should be filled up by you first?
They have to be. Yes, my lord. They have to continue the in-service quota, and then in the same vacancy round they have to decategorize. They cannot decategorize before that itself. When they have retained the seats for the other categories, my lords, what made them do it? Because my lords, it is their own department, my lords. My lords, it is their own department, my lords. They should first think of their own candidates who have been working there day and night for the pandemic also, and they cannot compete with the general category. My lords, it is very difficult because they have to work and then they have to study. That's the reason. There is a reason for giving a quota for in-service candidates. My lords, because they cannot compete with the general pool pressures. That's the reason they give them some certain percentage of seats, my lords. And they cannot now give away to the general pool pressures. And my lords, when the minister concerned says you reduce it, and who has taken the decision, my lords?
We don't.
That is what I am saying. They cannot do. My lords,
don't ask us. We don't know. We are.
I am not asking. What I am saying is, on what basis, my lord? There must be some order. There must be some decision.
It's a policy, right? I mean,
it is not a policy, my lord. It's
page 92.
Clandestinely, they have done it. They have not even published what they have done.
Page 92, madam.
Yes, my lord.
When it was published, page 92.
Page 92, my lords.
When it was published.
My lords, there is no date, there is no page number for this information bulletin, my lord. This is how they have maintained. Can you see, my lords? This is the.
So this has been
fraud.
subsequently
This is the
fraud.
Yes, my lords. What else, my lords? They don't even mention the page
Hey,
numbers.
Mister, your clients will go to jail, Mister. Both of your clients.
This is there with
This
all
is
the
fraud.
credits, my lord.
My lord, they don't even mention the page numbers.
Fraud. This is e-information bulletin you have manufactured overnight. What is this? No,
They don't even mention the date also. They don't even
no,
mention.
I don't go to the extent of saying fraud. We may
My lords,
ask
it
you,
is not that.
where have you said in the petition it's a
No,
fraud
I'm
and
not
all that?
saying, my
Then,
lords, it is.
then don't travel
Yeah.
beyond pleadings, man.
Let them give the date, my lords. Because we don't have information on this.
You have annexed it, madam.
My lords, I don't have the date. It is taken from their website. When was it published? We don't know. They don't date it.
So, under which? So, how did you appear in the examination? Tell us.
No,
Ask. No. Each of the petitioner will give an affidavit that he was not aware about the information bulletin. Which information bulletin? Any candidate, madam, will undergo. We will go through the criteria for the examination, the manner it will be held, and these doctors, if they are so ignorant, then they are not fit for
No,
to be
my lords,
doctors,
it is-
madam.
it is
No. Don't in
My
an
lords, it is
anxiety.
under 23rd
What?
of
Please
February.
understand. Please then file an affidavit of each one of the petitioners that he has seen it for the first time when you downloaded in your office this information bulletin.
I have not downloaded.
Then who has
They only-
downloaded?
they only
So,
their part.
so tell us when they have downloaded.
My lords,
Affidavit.
Yes, my lords. Kindly see, my
Affidavit.
lords, they
No.
didn't know about it.
We are, madam, we are
My lords,
taking
what
this. No. We are taking your assertion very seriously.
My lords,
That it is a. We will direct action against them, criminal case, if it is fraud, provided you have to establish. So first of all, let us forget about PG counseling. Let us first determine, you are saying this is a fraud. So who has, tell us who has prepared it, who has uploaded it on the website, who has done it? Tell us. You are saying it's a fraud.
My lords, they have
You
not
cannot
even
go
given
away.
the page numbers. They have not even given the date of
But
the.
so file an
Kindly see,
affidavit.
my lords.
No, madam. Before you say, first of all, this is not your pleading that page 64 is
It
a
is
fraud.
not. It is not.
Then that's the end of the matter.
My lords, I
So
withdraw
you
that
file.
statement,
So
my
first file the affidavit.
My lords, I withdraw as far as that is concerned.
Otherwise, these petitioners will face the
No,
prosecution. If it is found to be incorrect, you you cannot get away by saying everything.
Yes, my lords, I withdraw that statement. my
Fine.
lords.
So
Yes,
it's
my
not
lords.
a fraud.
Yes. My lords, kindly see Annexure B. They came to know about the NEET
Hey, you are
examination.
saved, Mr. Ramesh. Otherwise, your client would have landed in jail. Huh? So this
My lords,
allegation.
at least my lords, my lords, it is
All right.
brochure. They have to give the date and page numbers. My lords, page
No.
numbers are also not there.
Not given, that doesn't mean that it's a fraud, right? What do they get by
They have to
making
give
this?
proper information.
This on the basis of this information bulletin, madam, a whole examination in the state of Karnataka has been held, and nearly because a notification has been issued on 12th of March, you are saying that it's a fraud. Who will, if your client, just a minute, if your clients tell you that we were not aware about this information bulletin when we had written the examination, will you believe them? We are asking you only to file an affidavit. File an affidavit. And who has manufactured it? Did you file a complaint against the officers of the KEA? Who has manufactured it? Who has done it? Who has played fraud with you?
No, I'm trying that. That is what I'm
That's
saying,
it.
my lords. What?
Just a 1 minute, let her complete.
My lords, I say.
This argument is ensuing because of her allegation fraud. Fraud has to be, madam, has to be pleaded and proved. You cannot get away by oral submission. That's what we are telling you. Where have you said so? The fact remains that it's night today, and right now 9 p.m. Will you believe it? Mr. Then please file affidavit. We are prepared to send their officers to jail. We are prepared, madam. Don't worry. Don't worry about our powers. We do not have any doubt. They let the mop-up round be over. They will create extra. We have the power to direct them to create extra seats and to admit you.
My lord,
But but you must file an affidavit that it has been, please file. You told that it has been subsequently prepared. Please file. Please file. Please file the affidavit. Please file.
my lord, there is this clause says, my
Learned
lord,
counsel for the petitioner during the course of submissions
my lord, I
pointed
have
out.
no idea it is after the examination and all because my learned friend said this. Because I said that.
But you said that it's a fraud, right?
My lord, it is, I withdraw the statement itself. What I am saying
then-
is they have to be paid.
So it's better to confine you to legal submissions, the case which you have pleaded, right? Instead of going here and there. Fine. Fine.
My lord,
So-
kindly see. And I,
So you have worked during pandemic, therefore you are entitled to be rewarded. And minister has said that you should reduce, therefore they should reduce.
it is not that. What I'm
What
saying is they have been working day and night. They cannot compete with the pressures. Therefore, my lord.
That's what we said. You have worked during pandemic, therefore you should be rewarded.
Even otherwise they work because my lords, they have to work and they have to earn and then they have to give examination. Therefore, there is an incentive given to the in-service candidate. Take these seats. That's all, my lords, what I'm saying. And this clause, what my learned friend said, 92 page number. This also is very clear, my lords. The seats within the in-service quota shall be reserved as per the NCI, DCI government issued from time to time. Any seats reserved for in-service candidates which shall remain unfilled for want of eligible candidates, all otherwise shall be added to the non-in-service. My lords, it is only after the eligible candidates are over, after they take up seats, then only it should be given to the other category. That's exactly their own brochure also says the same thing.
All right. Anything else? That's all? Yes, Mr. Yes.
State government itself has prepared a separate benefit for us.
No. If they have prepared a separate merit, you should do it then. Have you prepared a separate merit list?
Only on merit, not on merit, they will be included.
Okay. Just which your petition, right? Annexure E. Annexure E.
Annexure E.
Yes. Page 20.
But the district 31.
Yes.
This is of the 30 candidates who have been made eligible by the in-service. Supporting the eligibility as well as the qualification for purpose of it as an in-service candidate.
Reduction of percentile, final list of in-service.
Comes to the weightage. I think the two for the included. Right?
35.
And this is forwarded as a separate to the government. Director of regulation is supposed to conduct a council. The government, on the basis of merit, there should be a common list of all the candidates on the basis of marks obtained at the board of examination. The very fact it presupposes a separate list for in-service candidates, it notifies that there is a list of in-service candidates to be filled. And when Lalupin has rightly read in page 92, it says after the in-service, page 65. Government issued from time to time. Reserved for in-service candidates which shall remain unfit for want of eligible candidates, otherwise shall be added to non-in-service quota of seats. So, the moment the benefit list of in-service candidates is already notified, for them to reduce the percentage, There cannot be a seat which cannot be taken with the quota of the reservist candidates. When the fact remains, there is a seat of, as my management arguments contended, there are the seat which is taken by a LT, ST or number of.
Okay, is there any petition in your government in your petition that these candidate, these seats are still unfulfilled? Remaining seats, 324 seats are still unfulfilled. Your petition there. Have you said anywhere that these 324 seats, which are 324 seats which were vacant after the first round of counseling have not been filled up? Have you said anywhere?
They not filled up is not making.
Not.
After the first round, they decategorized and merged with the non-incidents. First round is maintained for the students who have candidates who have got eligibility as per the NMC regulations.
Yes.
Only in the second round.
No, so now second round has, please understand, madam. Like these seats have been decategorized and have been filled up, right? In second category. Filled up.
It is.
And the quota of seats which not supposed to be filled up by the service candidates. Now decategorized, it is given up to the non-general candidates. As of the date of completion of second round.
All right. Yes.
Reason why we are before this one. You got it from
12th March 2012.
These are eligible and prior to that in preceding years also, previous years also. This is the mop-up round. There is no decategorization. For this is the first year they have done so far.
Where is that? Where have you said for previous round? Some movement has to be there. No? You cannot say anything like you feel like in the arguments, like your client must have told you yesterday. No, till last year it was not. We cannot. Where from he will answer, right? Additional government advocate wants material to answer.
Carry forward the reservations. The carry forward the reservations like action for all other candidates. Obviously, when the list is prepared for the interview candidate, there should be a quota of interviews. What have you continued with?
We don't know what we can. Who has prepared this?
This is the box prepared.
The chart doesn't contain the signature. Yes.
This is the director of
Director of Medical Education.
No, not medical. Director of Health and Family. After preparing this list is forwarded to the Director of Medical Education for in accordance with this list. It is addressed to the Director of Medical Education. So it is a list in quota of interview candidates. There is no inclusion of any general candidates here.
No, but you are saying that those seats have been filled up, right? You are admitting it second round. So, where is that? So what they have done, seat matrix?
In the seat matrix, as of today, there are 322 seats are being one vacant.
In service.
Not in service.
Then totality.
Because in service now. In service now they were.
No, you can, but supposing if there are 320, we just a query, 322 seats, you are eligible to participate as general category, right? As per merit, you can participate. All right.
For the in-service candidates, they cannot opt all the seats other than the clinical submission, which I have written in my decision also. There is a precondition for in-service candidates. Because even though I have secured first rank, I cannot take the paramedical seats or pre-medical seats. Though I am secured first rank. Because the rules precisely contained that I cannot take the seat which is not useful for that job. My submission is also. I know my limitation that now the seats of the service is not available. That is the fact. Now the profession notifying the vacancies available vacancies. But what is because in view of the fact that the service in-service quota has been taken away, nevertheless the merit list has been prepared. Allow to take the seats now. Because there is a two rider parts. Though we have not a merit, I cannot take all the seats. That part, our seats is already taken by decategorization. So allow us to take part first in the claim. because there are only 30 candidates who have been got eligible. Whereas for the other general candidates, they have got a reservation to take up SC, ST, PH, as well as other categories, because they have excelled by other categories. There cannot be due distinction between in-service and the classification of general category. If that is so, the government also had notified only on the basis of Indian merit list. There would have not been a merit list other than MBA mock. When the fact they have created and they have published it and they have forwarded the list of merit list of only in-service as a separate, the quota is not there, they should at least take part in the posting.
Anything else, madam?
Yes, my lords, it is, as of now, my lords, they are not supposed to take other than clinical subjects. They have to take clinical subjects, and now those clinical subjects are being given away to the non-in-service. Just now, even if they take, there is, because they have to, again, after the survey studies, they have to give 10 years more. So they like almost they come to the age of retirement, and after pharmacology and my lords, other non-clinical states, they are of no use for them. Because they cannot use in the department. Therefore, my lords, all those clinical seats which are being given away to the non-in-service, and that is general pool, that can be, my lords, reversed, because otherwise they are put, this happens, my lord, this is happening continuously. Then they cannot now, my lords, after certain age, they cannot even compete with the freshers. Now, if you with great difficulty, they have taken qualified, not qualified in the second round, that is in the reduction round. They can be given their own seats. That is what my submission before my lords. Otherwise, they, even after, if they don't opt now, my lords, if they pharmacology or anatomy, they are left out for them. They cannot take it, my lords. They have no use for the department itself. And if for the next round, if they have to write examination and qualify, my lords, it is actually tough for them.
Yes. That's all. Anything? Yes, Mr. Why have you prepared the merit list of in-service candidate if you don't want to give admission?
Those people who are eligible, irrespective of categories, we have allowed them to participate in the general.
But you have prepared a list of in-service.
Who are eligible. It is not that we are going to reserve a seat for them. Participate in this thing if they are eligible. Let them have the seat. General merit. Anybody can take the seat. If you get the subject also, fine. I can
work with the other person. And on the date of the exhaustion of the in-service quota, they had no other action at all. That point of.
So these general category seats, this in-service have been filled up. Second round.
All the seats.
25th February. That's it. Why yes? Give to Y1. Yes.
Yes, often with the eligibility is not or it cannot. If it is eligibility, the eligibility will be in the merit list because once they cut short the mark of 30%, on the basis of general list, we will be restricted to that. It is not necessary to send a separate in-service list.
All right. One more question, Mr. When this information bulletin was, yes.
After the examination is not from the NEET. Their bulletin is separate. This is after the NEET.
When? If you can tell us even
yes,
month also. Month also. That would do.
This is because this was pending before Supreme Court. So there are no counseling to take place. It is only after the Supreme Court.
No, we are asking the date only in the context of your submission. That's all. It's there in December 21. Fine. December 21. You don't know.
Maybe
At least some of the petitioners know that it is there since this.
Because it all depends on the only after they get qualified.
All right, so December 21, Mr.
It's always after the examination is over, before the counseling starts.
So examination took place when?
Examination took place in November.
October. All right. Thank you. So these are two cases, right? 40 and 41. Huh? 53, 40 and 53. 40, 41.
No, 40 and 53. 40 and 53, sir.
40 is your case, madam. 40.
Yes.
Which you argued
Yes,
just now.
yes, yes.
And which other case? 58.
53.
53.
Yes.
Oh, 53. And which other case?
Only two.
Only two.
Only two.
Only two. 41 and 53, right?
No, sir. 40 and 53, sir. 40 and 53.
All right. Thank you.
Number 41, Shri Abhishek Malipati, government advocate.
Same case, right? No. Grievance. Huh? Tomorrow? What is it? He has surrendered. Oh. So tomorrow? Mr. Abhishek Patil, learned counsel for the petitioner. Mr. N.K. Ramesh, learned counsel for respondent number 3, praise for short conversation. List tomorrow. It's 31st March.
42, Shri Sandeep Pingod, case
48. 148. IA 1 of 22 dispensation is allowed, then heard on the question. Mr. E.I. summary takes notice. Then this for analogous hearing state on notice dated
Both 30th June 2021.
30th June 21. Aisha A1 and A2. The proceedings shall remain state. This for analogous hearing along with ones. 18th April. You will argue 18th April. Mr. Salvati? No? Yes, Salvati. Mark is misleading. No? You are saying yes, we are hearing no. So, okay, yes.
admission, number 43, Shri Kapil Dixit.
Yeah.
Just for non-prosecution. Okay.
It is admitted for your issue.
Only notice.
It's a notice, only notice. Notice and record.
44, Shri Prasanna Vyas, Shri Satish Gogi.
It is admitted for hearing record.
I appear for respondents.
Yes.
45, Shri Jeevan K. V. Anand.
Admitted for hearing record. List for analogous hearing along with MFA number. Give it.
46, Shri R. Shashidhara, Shri S. C. Vijay Kumar.
Admitted for hearing record.
47, Shri Ganapati Bhatt Petroli, Shri Nathraj Bagar.
Select for the order. Send back actually.
Ex parte order.
I have stated in my appeal that the ex parte order, because we have tried several times and even after order we went there and they are not taking. Now the since this petition has been filed to show to avoid payment of the maintenance, and I am staying with my son in Tamil Nadu, and because they have thrown out me from the house, we went and we have several times.
Are you not interested to go back?
No, we are interested, but
Let him find out.
let them bring.
Let him find out. Next week we'll keep it.
Yes.
Learned counsel for the applicant states that she is ready and willing to join the matrimonial law. in view of opposite submission, Mr. Nataraj Ballar, learned counsel for respondent praised for short accommodation to enable him to seek instructions next week.
Ninth date, because he has
Just on
come from
9th,
9th or 11th.
9th April.
9th.
9th April 2020. Holiday? Oh, Saturday. 11th April 2020.
Party will be present before the court. Party.
Yes. Parties, counsel undertake that the party shall remain present before this court on the next date of hearing, then say list on whatever date. 12th April, 11th April.
Please.
11th April. Ask your plan.
48, Sri Dhananjay Kumar K, Sri Rakshit K.
Appeal is admitted for the hearing report.
Uh, 49, Sri Dhanraj HS.
I've done people transfer from saying for the expert in the matter for the conciliation and mediation.
Notice will have to be issued, right? Admitted for hearing issue notice on admission as in IA 1 of 2019. Record.
50, Sri Srikanth MP, Sri Prashant Kopet, Government Educate.
Some difficulty later. Some other.
Yes.
All right.
Please tell us which date. We don't know. You tell us, I mean, for
I am ready now. Pastor, I am saying some other.
Not this. But 5th April, fine. Learned counsel for the appellant praised for adjournment on the ground that the arguing counsel is not achieved this on 5th April 2020.
51, Diana Agreement.
There was a appellant in this case. Is a suit filed by the
husband. He can dismiss.
No, section 9 allowed.
Allowed. Oh, section 9 is allowed.
Yes, my lord.
It is admitted for hearing issue notice on IA.
My lord, I have also filed an application to it on.
What execution has been filed or not? No.
My lord, notice has been served to them, my lord. They have filed a caveat petition.
What? How is it executed, Mr. Execution?
They have not filed the execution act now, my lord, but in the last occasion they have submitted before the court below, my lord, they will file execution.
So we are issuing notice, right? Let's see.
But I have filed an application.
IA 1 of 21.
The lordship could stay the operation, my lord.
That's what we are asking you. How, first of all, in the first place, decree, any execution proceeding has not been initiated. So you can wait, like you can mention if you get a notice, right? Let's see.
But my lords, they are in the court, they have filed an execution petition for.
You said not filed?
No, execution petition with respect to claiming maintenance, my lord. What order?
Maintenance.
In the said petition, my lord.
Maintenance you will have to pay, right? Irrespective of the fact whether she stays with you or.
Yeah, my lords, but in the said proceedings, my lord, she told, I'll file execution petition and I'll come to your home like that. She's submitting.
So that's what we are asking, how it is executed. The decree.
Honestly, my lord,
nothing. Let's see.
Her husband has
we are granting you liberty, right? In case any coercive action, that's what we have asked. Yes. Fine.
But my husband has also filed one more MFA, my lord.
Which
MFA number
along with MFA number
5591 of 2021.
5591 of 21.
And there, my lord, a call for LCR has been done, ordered.
We come up both of them. We just wanted you to tell us how it is executed. You are not telling us. First of all, execution proceeding has not been filed, right?
She has not been filed, but she is orally harassing petitioners. She will come and she'll come in front of your house.
What orally? So you will go in front of her house and tell that I've got a stay from the High Court Delhi. We don't want that. That is orally harassing. What orally harassing?
She succeeds in filing execution.
No, so you will, I mean, supposing if we grant stay tomorrow morning, you will tell her I have got stay from the High Court. Don't go away. Like that's what. Orally harassing means what? Nothing is being done.
I will submit it in the court below. Let's stay at granted.
Nothing. Don't submit. You tell the court that notice has been issued on my application. No threat.
Since she has filed a petition, notice has already been served to the appeal counsel.
Their name is not shown, Mr. Avatar's name is not shown.
I'll submit.
Yes.
52, the Amerasian.
What?
Senior on his next match.
Get it. So what is it about? You tell us senior, let him remain where he is. You tell us, you are before us. So what is this review petition about? Who is the senior?
Amarish.
So is this the way to tell the court at 2:30, 4:30,
No, another
3:50? No. You have to ask you. Is it the way he is a designated senior counsel? No. Then you are first telling that senior, that is itself is a misleading. You should say that my senior. Fine. You are trying to give it as if, pass it on as if he is a designated. He is not a designated senior counsel, number one. Secondly, you don't have any right to tell us that at a particular time the case should be taken up. So we will reject the prayer by imposing the cost of 5,000 rupees.
No, I'm sorry. Kindly pass.
No, 2:30 you said. We are asking you why. How could you make this prayer that 2:30 it should be taken up? We take a serious exception to this.
I'm sorry. I'm sorry for that.
Kindly you tell us now what is the review petition about? You tell us. If you are really sorry, you should be able to tell us what is the review petition. Yes. Yes. Against which order the review petition has been filed?
It is the annexure A.
It's against annexure C, not A.
This is input.
What has been done?
That is the dismissal.
What is dismissed? You can tell us your name if you can.
Name. Prasad.
How many years of practice?
From 2013.
It means how many? 8 years. Right? About to become eligible in 2 years to cross the floor. Constitution says any person who has put in 10 years of practice can become a judge of this court, right? And some eminent jurists can directly be elevated to Supreme Court under Article 124. You are even unable to tell us, sister, what is the review petition about? So think about your future as a in the profession, right? Write his name. We should notice.
Our matter.
Get it? Tell him.
Yeah, we should notice.
You are still looking at us, and sir, what else? We will not award you 25,000 rupees for telling us your name. We can't direct legal service authority to give you a sum of 25,000 for telling the name. Not there, mister. You should come at least go through it. What is the case? And don't tell at least in this court 2:30, 4:30. We will set you right. has been filed. This is WP 6735 part 2022. 22. This writ petition has been filed by the petitioners who are in-service candidates for a direction to the respondents to decategorize. No, for a direction for direction to declare the merger of decategorized in-service quota seats with general merit quota seats as null and void, and to direct the respondents to revive stroke restore the entire in-service quota seats which have not been filled up after completion of the first round of counseling. The petitioners also seek a direction to the respondents to permit them to appear in the mop-up round as in-service candidates and to fill up the remaining vacant seats of in-service quota candidates by selecting the petitioners. Full stop. In order to appreciate the petitioner's grievance, few facts need mention which are stated in paragraph. The petitioner are in service. The petitioners are MBBS. Petitioners are doctors. Petitioners are doctors who are serving with the director, Family Health and Family Welfare Department as general duty medical officer at different primary health centers in the state of Karnataka. Full stop. The state government Karnataka conduct of entrance test for selection and admission to postgraduate medical and dental degree and diploma rules 2006, herein after referred to as PGET rules. PG capitals PGET 2006. Full stop. The aforesaid rules provides that the petitioners that in-service candidates eligible to compete for in-service quota postgraduate medical seats. Paragraph. The National Board of Examinations conducted NEET PG entrance test in the month of on 11/9/2021. The results of the opposite results of the opposite examination were announced on 28/9/2021. The National Board of Examination notified 302 marks as cutoff score for general category candidates, whereas general category is all cutoff score, right? The thereafter the respondent number, thereafter the Karnataka Examination Authority, herein after referred to as the authority, issued the information bulletin for counseling of the petition itself. It is written. MDS stroke MD stroke MS. Full stop. Admittedly, the first round of counseling was conducted. Full stop. The information bulletin issued by the authority contains a stipulation which reads as under page 90. The line below. Thus, it is evident that in terms of the information bulletin, the seats within the in-service quota which remain unfilled for want of eligible candidates or otherwise shall be added to non-in-service quota seats. Full stop. Paragraph. For the NEET UG examination, NEET UG 2021, 309, no, not examination. This 396 seats. Paragraph 390. The authority, the state government reserved 396 seats for in-service candidates. Full stop. In the first round of counseling, 70 all eligible 72 candidates were allotted the seats. Thereafter, the remaining seats were allotted in first round of counseling, which was held on 25th January 2022. Thereafter, the remaining vacant seats were decategorized and were admittedly filled up from amongst the general category candidates in the second round of counseling, which was held on 25th February 2022. Paragraph. Thereafter, the National Board of Examination issued a notification dated 12th of March. This is paragraph. 12th of March 2022, by which the percentile for percentile cutoff marks for NEET PG examination was revised. Full stop. It is the case of the petitioners that after reduction in the cutoff percentile by the national by National Board of Examination, the petitioner became eligible to participate in the counseling. Full stop. The petitioners have therefore filed this petition seeking a direction to the respondents to fill up the remaining seats of in-service candidates from amongst the petitioners who are in-service candidates. Full stop. Paragraph. Learned counsel for the petitioner submitted that the petitioners are in-service candidates who have worked during the pandemic, and therefore an incentive should be given to them by reserving the seats for them. It is further submitted that however it is fairly submitted that all remaining unfilled seats of in-service candidate after the first round of counseling have been filled up in the second round of counseling by general category candidates on 25th of March 2022. It is also pointed out that the Director Health and Medical Education has prepared a separate merit list of eligible in-service candidates, which indicates that the petitioners deserve to be treated as in-service candidates for the second round of counseling, and remaining vacant seats of in-service candidates should be filled up by admitting them to the course. Full stop. Paragraph. On the other hand, learned counsel for the respondents submitted that since the number of seats were more and the number of eligible candidates were less, therefore the remaining vacant seats after admission of all the 72 candidates who were eligible under the in-service category quota, remaining 324 seats of in-service candidates have been filled up in the second round of counseling on 25th of February 2022. Full stop. It is further submitted that that at this point of time, it is further submitted that that the petitioners are eligible to appear in the mop-up round of counseling as general category candidates, and their candidature shall be considered as per their merit. Paragraph. We have considered the submissions made on both sides and have perused the report. Full stop. Admittedly, after the examination was held on, what date? Examination was held on 11th of September 2021, the authority had issued an e-information bulletin pertaining to NEET PG 2021 examination in the month of October, right? What did you say? In the month of October 2021, before the counseling had commenced. Full stop. In the month of October, December, in the month of December, before the counseling had commenced. Full stop. The aforesaid information bulletin clearly provides that the seats which are remained unfilled for want of eligible candidates in the seats of in-service candidates, which remain vacant after which remain unfilled for want of eligible candidates shall be filled up from amongst the non-in-service quota seats, from amongst the non-service candidates, right? Full stop. Admittedly, full stop. The petitioners have not challenged the aforesaid stipulation provided in the e-information bulletin. Full stop. It is pertinent to note that admittedly, all remaining vacant seats of in-service candidates have been filled up in the second round of counseling on 25th February 2022. Full stop. At this point of time, there are no vacant seats of in-service candidates, which can be made available to the petitioners for their admission. Full stop. Therefore, no relief. The candidates, the petitioners have neither chosen to file the particulars of the candidates who have been selected against in-service category candidates, nor have implicated them in this petition. Full stop. Therefore, at this point of time, no relief can be granted to the petitioners in the absence of the candidates who have been admitted, against the vacant seats of in-service candidates after the first round of counseling. Full stop. The petitioners do not have any legal right. Petitioners do not have any legal right to seek a writ of mandamus to the respondents to insist that the seats which have already been filled up, that the seats which should have already been filled up, should be decategorized and should be treated as in-service category seats. Full stop. Category seats. Full stop. The petitioners are eligible to appear in the mop-up round as general category candidates and would be given admission if they are found eligible as per their merit. Full stop. Candidates in the mop-up round and would be given admission if they are found given admission as per their admission if found eligible as per their merit. Full stop. Paragraph. For the aforementioned reasons, we do not find any merit in this petition. The same fails and is hereby dismissed. The other thing is another petition is WP number 53, not 53 number 6617 /2022 for the reasons assigned. mark the presence and they say for the reasons signed in 41. This is
Passport matter, December 18.
Oh, yes. Oh, your daughter is married, right? You asked her what.
Yeah, both of them are present.
Petitioner is not the daughter. Petitioner is the boy.
Oh, so nothing survives, right? This petition is.
But they are not, they have not been produced. Instead of giving a complaint.
ಯಾರ ಜೊತೆ ಬಂದಿದ್ದೀರಿ ಕೋರ್ಟಿಗೆ?
Come here, madam.
ಯಾರ ಜೊತೆ ಬಂದಿದ್ದೀರಿ ಕೋರ್ಟಿಗೆ? ಅಪ್ಪ ಅಮ್ಮನ ಜೊತೆ. ಇವನ್ ಪೊಲೀಸ್ನವ್ರು ಕರ್ಕೊಂಡ್ ಬಂದ್ರಾ? ಎಲ್ಲಿಂದ ಕರ್ಕೊಂಡ್ ಬಂದ್ರು? ಸ್ಟೇಷನ್ಗೆ ಯಾಕೆ ಹೋಗಿದ್ರಿ ನೀವು? ಮನೆಯಿಂದ ಕರ್ಕೊಂಡು ಹೋದ್ರ? ನೀವು ಮನೆಯಲ್ಲೇ ಇದ್ರಿ? ಎಲ್ಲಿದ್ರಿ ನೀವು? ನಿಮ್ಮ ಮನೆ ತಂದೆ ತಾಯಿ ಜೊತೆ. ನೀವು ಈ ಪ್ರಶಾಂತ್ ಅಂತ ಹೇಳೋರ ಜೊತೆ ಮದುವೆ ಆಗಿದ್ದ ನಿಮ್ದು? ಮದುವೆ ಆಗಿದ್ದೀರಿ. ನೀವೀಗ ಯಾರ ಜೊತೆ ಇರ್ಲಿಕ್ಕೆ ಮನಸ್ಸಿದೆ ನಿಮ್ಗೆ? She says that she wants to go with Prashant.
Oh, you know, she knows, right? Marriage.
She says I am married to him.
What is her age?
ಎಷ್ಟು ವಯಸ್ಸು ನಿಮ್ಗೆ?
Age, date of birth.
22. 2000.
What date of birth, madam? 22/6/2000.
ಏನಾದ್ರೆ ನೀವು ನಿಮ್ಮ ಡೇಟ್ ಆಫ್ ಬರ್ತ್ ಗೆ ID ಕಾರ್ಡ್ ಏನಾದ್ರೂ ಇದೆಯಾ ನಿಮ್ಮ ಹತ್ರ? ಏನ್ ತಂದಿಲ್ಲ.
Was she detained by anyone?
She says I was in my parents' house. But I'm married to Prashant and
All right, yes. This petition has been filed seeking a writ of habeas corpus. Produce Srimati Sushmita, who is Sushmita, paragraph. The petitioner claims to have married the detainee, namely Srimati Sushmita, full stop. The learned additional government advocate, now SCGP has produced Srimati Sushmita before this court. This court interacted with Srimati Sushmita, who told that her date of birth is 22/6/2000 and she was staying with her parents. It is further stated by her that she is married to the petitioner, namely Shri Prashant, and wants to stay with him. Full stop. The opposite statement is taken on the parents, right?
Yes, parents. ಬನ್ನಿ ಮುಂದೆ ಬನ್ನಿ.
The opposite statement is taken on record. Nothing statement is taken on record. Therefore, nothing survives for adjudication.
ಈ ಕಡೆ ಬನ್ನಿ, ಈ ಕಡೆ.
Same is this full stop.
ನಿಮ್ಮ ಮಗಳ ಡೇಟ್ ಆಫ್ ಬರ್ತ್ ಯಾವುದು? 2000. ಅಂದ್ರೆ ಅವ್ರೀಗ 21 ವಯಸ್ಸಾಗಿದೆ. ಅವರಿಗೆ ಮೇಜರ್ ಇದ್ದಾರೆ. ಅವ್ರು ಮದುವೆ ಆಗಿದ್ದ ನಂತರ ಅವ್ರ ಜೊತೆ ಹೋಗ್ತೇನೆ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ಮೇಜರ್ ಇದ್ದಾರೆ, ಮದುವೆ ಆಗಿದ್ದೇನೆ ಅಂತ ಹೇಳಿದ್ಮೇಲೆ ಗಂಡನ ಜೊತೆ ಇರ್ಬೇಕಂತ ಹೇಳಿದ್ರೆ ಏನ್ ಕೊಡ? ಅವ್ರು ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಮದುವೆ ಆಗಿದೆ ಅಂತ ಹೇಳಿ. ನೀವು ಆಗಿಲ್ಲ ಅಂದ್ರೆ ಮದುವೆ ಆಗಿದೆ ನಾನಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಕೋರ್ಟ್ ಅಲ್ಲಿ. They say that marriage has not taken place. ಎಲ್ಲಿ ಮದುವೆ ಆಗಿರೋದು? ದೇವಸ್ಥಾನದಲ್ಲಿ? ಯಾರೆಲ್ಲ ಇದ್ರು ಮದುವೆಯಲ್ಲಿ? ಇಬ್ಬರೇ ಸೇರಿ ಮದುವೆ ಆಗಿದ್ದೀರಿ? ಮದುವೆ ಆಗಿದೆ ಅಂತ ಹೇಳ್ತಾರಲ್ಲ ಅವ್ರು, ಏನ್ ಮಾಡೋದು? ಮದುವೆ ಆಗಿದೆ ಅಂತ ನಾನು ಅವ್ರ ಜೊತೆ
say here that offense has been taken on record. Will say one sentence. It is made clear that this court has not expressed any opinion with regard to validity of the marriage. Then the petition is disposed of. Fine. Do whatever. Tell them.
ಹೇಳಿ, ಏನು ಹೇಳ್ಬೇಕಾ? ಏನಿಲ್ಲ. ಸರಿ, ಅಷ್ಟೇ. ಅದಕ್ಕಿಂತ ಜಾಸ್ತಿ ಏನು ಹೇಳಲಿಕ್ಕೆ ಆಗುದಿಲ್ಲ. ಅರ್ಥ ಮಾಡ್ಕೋಬೇಕು ನೀವು. ಅವ್ರನ್ನ ಜೋರ್ ಮಾಡೋಂಗಿಲ್ಲ ನೀವು. ಅವ್ರೇನು ಮದುವೆ ಆಗಿದ್ದಾನೆ ಅಂತ ಹೇಳ್ತಾರೆ, ಕೈ ಮುಗಿತಾ ಇದ್ದಾರೆ, ಗಂಡನ ಜೊತೆ ಹೋಗ್ತಾ ಇದ್ದಾರೆ ಅಂತ ಅರ್ಥ ಮಾಡ್ಕೋಬೇಕು ನೀವು. ಮದುವೆ ಆಗಿದೆ ಇಲ್ವಾ ಅಂತ ಹೇಳಿ ಅವ್ರು ಹೇಳ್ಬೇಕು, ನೀವ್ ಹೇಳೋದಲ್ಲ. ಭಯ, ನಿಮ್ ಬಗ್ಗೆ ಭಯ ಆಗ್ತಾ ಇದೆ ಅವರಿಗೆ. ಮದುವೆ ಆಗಿದ್ದಾರೆ ಅಂತ ಹೇಳಿದ್ರೆ ನಿಂತ್ಕೊಂಡು ಮದುವೆ ಮಾಡ್ಕೊಡಿ. ಆಯ್ತು. No, that is for her to decide.
For her to hear recorded her statement. She is free.
ನಿಮ್ ತಂದೆ ಜೊತೆ ಹೋಗ್ಬೇಕಾದ್ರೆ ತಂದೆ ತಾಯಿ ಜೊತೆ ಹೋಗ್ಬೋದು, ಅವ್ರ ಜೊತೆ ಹೋಗ್ಬೇಕಾದ್ರೆ ಅವ್ರ ಜೊತೆ ಹೋಗ್ಬೋದು. ಯಾರ ಜೊತೆ ಹೋಗ್ತೀರಿ?
As residing with her parents and has not been detained by them against her wishes. That's all. Only one add there, no? Residing with her parents and has not been detained by them against her wishes. Then says she is married. Fine.
ಆಯ್ತು.
All right.
ಅವ್ರ ಜೊತೆ ಹೋಗ್ತಾರಂತ ಹೇಳಿದಾರೆ, ಅವ್ರು ಹೋಗ್ಲಿ.
Milord, she is free and willing to go with the petitioner.
We have said so. She is at liberty.
Yes.
She is not detained by them, right? You tell them don't detain.
Yes. You can. ಅವ್ರ ಜೊತೆ ಹೋಗ್ಬೋದು ನಿಮ್ಗೆ ಹೋಗ್ಬೇಕಿದ್ರೆ. ಹೌದು, ಆಯ್ತು. ಅವ್ರ ಮನೆಯವರಿಗೆ ಹೋಗೋರಿಗೆ ಸ್ವಲ್ಪ ನೋಡ್ಕೋಬೇಕ್ರಿ.
Yes.
Lords, Lordship may kindly pass over, my lords.
Respondent, my lords.
Lords, I seek for a pass over, serial number 54.
My lord, I am appearing for the petitioners, my lord. This is a petition filed by the retired employees of the subordinate courts, my lord. They have challenged the C&R rules amendment. The rules have been amended.
2 weeks time.
My lord.
Speak loudly, Mr. See, we are not your spokesperson, right?
Appear from state government.
He wants adjournment, nothing else. What you know that what else he will do? Learned additional government advocate for respondent 1 and 2. Grace fund is granted 2 weeks time to enable him to file objection.
Obligement.
All respondents for respondents. Then write his name. Praise for and is granted 2 weeks time to file objection.
Yes. Obligement, my lord.
Counsel is arguing from Mumbai.
I appear for the first respondent.
What is the matter?
It's a GST matter. The so-called notice is being issued on the development rights.
And in the virus also provision. Also.
Final hearing number 57, Amit Deshpande, TM Nayak.
Oh, yes. What is it? You lost the file, right? It's the same case. You got it. Oh, good. Yes. What is it? Tell us. Your wife or husband? Husband. Oh. What? You sit down. Don't worry. We'll get him. Who is the counsel? Naik. PM Naik. Message and it will be displayed. So we can tell him, right, that we should say that PM Naik is required in court hall. Display, you can show the message that Mr. Naik is required in this court hall. Yes, message. So that he knows. Yes. What I was. So you do it every case. What is it, Mr.? Yes, yes. What is it? This. Oh. He has come. No, he is not there. Oh, he's the advocate. Yes. Oh, you filed it on the ground of desertion. Cruelty. What is when the marriage takes place? What is the date? Date status? So you have to keep us engaged till this thing comes. No, Mr. Naik comes. No, nothing. Today is the most auspicious day. 10 years after 10 years. You have completed, no? Fine. Ready? Let's see. So what happened? So 26th January.
What is he doing? What is he doing? Software engineer.
Now he doesn't do anything, right? No, because we are repeatedly told that husband is not doing anything now. Agriculture. Oh, good. It was born. Oh. What happened to daughter?
With him.
Husband. Oh. So what? So you have filed on the ground of what? Desertion and cruelty. So according to you, when she left the matrimonial home, your wife? Yes, January 2005.
It was born on 19-1.
I will left the matrimonial home on 10 January 5. And when did you file the petition? A record is there, Mr. Mo.
Petition is filed on 17/2/2010. 17/2/2010.
What is the cruelty? CH-2 is what?
The custody of the child is given to you in a separate proceeding. That is after this. There is an appeal before this court.
May I represent, my lord? I'm appearing for.
Of course, yes, yes. Yes. Oh.
Yes,
Good
my
that
lord.
you have responded to the message sent by the court officer. Yes. Your client is sitting here waiting for you anxiously. So,
Yes, my lord. Sorry, my lord.
Fine, fine. Good. He is arguing. Mr. Deshpande is just telling us when you got married, what happened. Nothing. Yes. What is exhibit P2? What is it?
Some mistake,
Awesome.
Sorry, my lord.
Doesn't say. I mean, this message may be all right, but where is the allegation? Your wife is very generous, right? In showering praise on you, exhibit. Yes. Not all is proved, right? Exhibit 2, P2, etc. is proved. No, but this is admitted. But the limit time is rules that can't be acted upon. It can't be acted upon. 65B4. Because that is the sole reason on which we enter. Either also not a pleading. Where is it admitted?
That does not mean they have admitted it.
Yes. As an exhibit, that doesn't mean that you are not required to prove it. So why desertion has not been proved? Desertion. No finding. Right? That's right. If I given out means that doesn't amount to desertion. You first argue with reference to evidence. We'll see what it is. What is the pleading? What is the evidence? What is desertion? What is validity? Which paragraph you will read? Join us. That's why. Searching for file. Yes. Well. Where the cruelty and this thing you have pleaded? Wait, no. No. Within how much time will you produce? How much time will you produce the documents? You have got the documents, right? I need. You are the counsel for the. So next stage, please ask me. You are the counsel for the appeal case for not adjournment to in order to enable him to do on the court case. Are you open activity? Tell us which date. 6th April, 6th April, 6th April 2020.
Mr. Naik. Naik.
42 development, 42. Once marriage is fixed. Once the marriage is over. Some positive response from that side. But for marriage, yesterday itself I said, my Lord, we incorporate. That's most important.
You wanted to hurry, you started arguing.
I didn't know. Marriage, my Lord, I didn't know. I'm sorry, I didn't know. Person, I had no knowledge at all.
After summer vacation.
Yes.
Married counsel for the appellant jointly pray for adjournment list article, including summer vacation.
Will you apply?
59. Prabhupada de Tumge, Vidya Rajeshwari.
My lord, I represent the respondent in this case, both the cases.
Patient statement decree should be granted. And we also have that when he appears to this thing, I will, if this was to continue, I will bear this. Yes.
In both the cases, I represent the respondent, my lord.
Respondent, who is for the appellant?
Prabhupada de Tumge.
Pastor.
Number 60, Sri R. Hemant Raj, C.S. Nagaraj. Number 61, Sri Ajay Kumar Patel, Sri N.K. Ramesh, Sri Sharana S, Sri N.R. Bhaskar, Pradeep C. Yadav.
I'm for the respondent's counsel, my lords. 61, I am for the respondent's counsel, my lords.
So appellate petitioner is not there. Password. Yes.
But can it be taken up some other day, my lords? 2:30 is a little.
We'll see.
Very well, my lords. Very well, my lords.
Oh, 59 you are for the appellant. Who is for the
Srimati T.R. Rajeshwari, serial number 59.
Yes, my lord. I am for the respondent in this case, my lord.
You are not Mr. Nayak.
No, my lord. I extremely apologize with this honorable court, my lord.
So you appeared in
because I was in civil court when I saw the cause list. It was 50 serial numbers 50 was going on. So I
Deshpande was confident that nobody will appear on behalf of respondent.
Yes,
And you
I
made it
extremely apologize.
uncomfortable by appearing in his case.
No, my lord.
No.
I was very much interested. I was in civil court, my lord. When I saw the cause list, it was.
Then you ran here, right? So yes, word. What is it?
Serial number 51. Hence, I came up hurriedly. And I thought that my case is going on.
Fine. It's all right.
That's why, my lord.
We are hearing the other
Yes,
side. You reply after he is finished. Yes.
Yes,
No instructions. Then evidence is there with him. You have the evidence, Mr. Evidence. Yes. You take it. Nothing, but no, you are not satisfied that it is pending for 6 years. Want that it should remain pending for another 6 years or what? Why? See, after admission, We don't know why you should not avail of this opportunity. I mean, as if we feel like we are parties to the appeal and we are going to get the relief if it is allowed or dismissed, something like that. You don't seem to be in hurry, or client doesn't ask you what is happening to my case. Doesn't never ask you.
Yesterday I called him and not informed him. He's out of station, it seems not certain.
But you have drafted the appeal, right? Then how without going through evidence? You want to say that without going through the evidence and papers, you have drafted the appeal? You want to tell us that? It's all live streaming, Mr. You must have told your client, right? The bench is not good, it will dismiss. It's pro-wife and like that. That's why you are so comfortable seeking an adjournment. Doesn't know. Oh, you must have told something. You must have told him something about us. No. So why after 2 weeks? Why not after this thing vacation? No. So that's why we are asking. No. Why next week? We are saying why not after 4 weeks? Who will see? The days are numbered, like 16, 17 days. Why should you trouble at everything? Today we have reached this number, right? You are when the day we reach the number, you seek adjournment. And then requested. What? Yeah. So after vacation, then, not before that, because your client is not in a hurry. He is traveling. He must have forgotten about the case. Then it counsel for the appellant prays for adjournment list after 4 weeks. List after ensuing summer vacation.
That's serial number 62, my lords. I've been instructed to, yes, my lords, I've been instructed to appear. It appears a counsel, my lords, is entered appears. Vakalat's file.
Yes.
Lords, I'm instructed that the Vakalat's file and it is not put up, my lords.
No,
he has already engaged an advocate. His name is not shown.
Mr. Ravi Shankar is appearing for.
Lords, on behalf of Siri Rajshekar, she has filed the Vakalat, my lords.
Siri Rajshekar has filed Vakalat.
Acha. All right. So, Mr. D.R. Ravi Shankar. So, what do you want, Mr.
Lords, it appears, my lords, by an order dated 21/8/2017 at a point of time when the petition was appearing as party in person. Notes when he was required to take notice to R3 and R4 who would be otherwise contesting respondents, he had sought for dispensation of notice to these respondents. Notes he has filed an application on 30th of December 2021. Notes your lordships may not be.
You have to argue this. I mean, it's a tricky issue, not like that.
Third and fourth respondents.
What is you are ready? We can go ahead.
Notes I'm not. I have on the merits. Notes if this is restored, notes then I can. Otherwise, there may be a difficulty of procedurally. There may be a difficulty to go on with this.
The counsel himself made a prayer, right?
No, the party in person.
No, not in person. The counsel. That's what we told him. Please go through the order sheet. The counsel himself said that they will be dispensed with. It's not that we would have been understood that he didn't know and all that. 5. What do you want, Mr. Ravi Shankar? Tell us.
If third and fourth respondents are not there, minutes, I don't think I can argue this.
No, we will take up once you are ready. Whatever we will decide. If you are ready, we can go ahead.
I can. But what I personally felt after going through the papers, minutes, is that unless 3 and 4 are before the court, minutes.
No, the application is there. We will have to consider it.
Yes, minutes.
You are ready to address.
Can be taken up on some other day, minutes. I'll address argument.
That's what we are doing.
Very well.
Mr. D.R. Ravi Shankar, senior counsel for the applicant, Mr. T.P. Muthanna, counsel respondent. office is directed to reflect the name of Mr. Sarvana as.
Yes, Sarvana, my lords.
As
Siri
Sarvana.
Rajshekar.
Siri Rajshekar.
Siri Rajshekar.
Siri
SIR.
Rajshekar. As counsel for applicant, learned senior counsel prays for short accommodation. Wait, next week?
Any day, my lords, next week.
Yes, next week. Yes, next week.
Number 63, the C.R. Raghavendra. Comment advocate, given any delegate?
Yes. Other food. Okay.
Number 64, Dr. Saki Shamu, party in person.
Yes.
Srinivas Rao.
Yes.
It's the case of promotion from the year presently 1995. I would like to brief with the brief facts.
Give the synopsis. We have the synopsis, facts, etc. Give him also copy. Yes. Yes.
My lord, I was appointed as lecturer in the year 1987 in the GMS Evening College of Engineering. Just I'll take few minutes, then I'll come back. Then I had applied for the post of assistant professor by direct recruitment as per the advertisement in the GMS Day College. Both are aided institutions under the same management. I was rejected for the sole ground that I had less experience, which was erroneous. Then I ignored that and went ahead. And in 1994, they had advertised again. Then there also they rejected. 97 again, 96 they again advertised, they rejected. Then, because they had not considered my case, I approached the commission, National Commission for Quotas, New Delhi. There, our college authorities were summoned and direction, recommendations were issued. As per that, I received the appointment order on 15/7/1997. Then they did, and on the next day, 16/7/1997, they issued another appointment order to another candidate who appeared on the third interview. But the post was only one. There the dispute arose. Then I approached the court. Finally, in petition 18119, that's very important for me. I had prayed, which is on page 53, my lord. There was this petition filed under Article 226 and 227 of the Constitution of India. They affect the official memorandum 15/7/1997, Wired Annexure J, where the petitioner is appointed as still proceeding civil effect from 31/3/1992 and give him all the consequential benefits from 31/3/1992. This was my prayer. This is the beginning of this litigation. Then, in the same order, on page 60, 57, my lord, the writ petition stands allowed. The influence orders are set aside. The matter is remitted back to the director. Time for compliance is 2 months from today. Later, they had to invariably remove the other candidate who was appointed on the next day. And they gave me the approval on 2/9/2003, which is on page 68 and 69. The English version is 70 and 71. Because the other candidate was removed, the High Court, and finally it was adjudicated that both of them should get appointment, and that order is on order IA1 on page 72 and 73, my lord. There, it was mentioned that the candidate will get from 16/7/1997 the other candidate, and I would get from 3/6/1997. But that was wrong, and then they corrected it as 15/7/1997. The day the appointment order was issued, that date was given to me, but not from 1992 as per the appointment order, for which I went before the division bench, and in writ appeal 908 of 2006, I went before the division bench. The order is on page 74, beginning. Then in the last page number 82, the reasons stated above, the influence orders 12/12/2005 was by the judge set aside. Insofar as the appellant is concerned, it is declared that so long as an actual order dated 2/9/2005 there is a dimension force, the appellant will be entitled to consider in care of assistant professor from 31/3/1992. So the division bench decided my seniority as assistant professor from 13/30/1992 as per the orders of the but the college did not stop there. They went before the Honorable Supreme Court of India, and on page 84 and 84, having heard in the Supreme Court, the Supreme Court notes, having regard to the background facts in which we present special leave petition, we are not inclined to interfere in exercise of our jurisdiction under Article 136 of the Constitution.
accordingly, our question of interest, so on, left open. Thereafter, the college issues me a fresh appointment order, which is on page 86. Implementation of the order passed by the Honorable High Court of Karnataka and writ appeal 908 and so on. So there they give me the benefit of the assistant professor from 1992 itself, based on the orders of the division bench. Then now they gave me only the assistant professor, not the consequential benefits flowing from that. In the writ petition, I had mentioned with all consequential benefits, which was adjudicated before the CL judge. Thereafter, I got my assistant professor post, and with all consequential benefits, they did not do it. They gave only assistant professor. As per the cadre recruitment rules, this happened. This order was passed, Supreme Court order on 11/9/2009, and I received my appointment order, a new appointment order, 1/10/2009. As per the prevailing CR rules of that day, I am entitled to become professor from 1995. That's the case actually. And for which I gave my representation on 8/10/2009, which is on page 87, 88. And I asked for the seniority list. 88, and the violation of Article 14, 61, and all that I had mentioned, and asked for the post of professor from 1995. There's on my appointment as assistant professor from 1992, as per the C&R 1987. The seniority list is on page 90, my lord, where my name appears as serial number 1, page number 90. Then, since they were not interested in giving me the benefit, I went before the Karnataka State Commission for Scheduled Castes. They finally decided that let the legal opinion of the state government, principal secretary, state government, let it be done, which is on page 106, my lord, the order. Based on the facts of the case as noted above, is directed to appoint of CH-2 professor in Department of Civil Engineering, BMS College, post of assistant professor, with effect from 3 to 1992 as professor, and with effect from 3 to 1995, grant all consequential benefits based on the opinion of the principal secretary of the law department. They left it to the law department of the government. Then the law department passes after the file, perusal of the file, they pass an order, the opinion, which is on page number 126, the English version. The last paragraph, 39, serial number. Hence, it would be just necessary to grant the promotion of the applicant CH-2 as per C&R 1987 from the date of his eligibility, that is from 31/3/1995 itself. This was passed an opinion given by the State Law Principal Secretary. As per the direction and recommendations of the Commission. Commission did not take any decision, it left it to the Law Secretary. They gave the opinion that I should get from 1995. Later, on page number 108, my lord, very interesting. On page 109, the English, that is the Kannada version, the English version is on page 116. They gave me an endorsement dated 6/5/2013, state government, even after the opinion of the last year's law secretary, the state government gives an endorsement on 6/5/2013, the English version 115, page number 115. And on page 116, that's the extract of the government order, where serial number 3, professor and qualification and experience. The word for promotion there is not there in the government order. They were inserted into this endorsement by the government. I would like to show that. Page 153, my lord, that is the extract. Serial number 3, professor, qualification and experience. Page 153. That's the extract which they have reproduced in this endorsement. There we can see the two words for promotion, which is underlined, are absent in the government order, but they have intentionally, inserted those two words into this. They misled by giving this endorsement that for promotion also PhD is necessary. But this qualification which is prescribed at 153 page number is for direct recruitment only as per AICT, not for promotion. You can turn to page number 144, my lord. The government order says at 6.2, 144, 6.2. Appointment to the post of lecturer, assistant professor, and principals shall be by open selection on the basis of merit as per prescribed qualification and experience. Placement is senior scale selection grade in case of lecturers to be promotion as per condition prescribed. So AICT is very clear that it should be by open selection only. Whereas our C&R rules, which are there on page 131, 131, page number 131, it starts. Serial number 2, measure of recruitment and minimum qualification. And B, A is about the category of posts, etc., what it means and all that. B, I would like to read B, is very important. Posts for which All India Council for Technical Education has prescribed recommended minimum qualification. The same qualification shall apply to this post in respect of other posts not covered by All India Council for Technical Education. The qualification as prescribed in this rule shall apply. It means that whatever AICT has prescribed for open selection, if it is not followed, what is followed for promotion, AICT promotion, the C&R rules 1987 has to be adhered to. And on page number 133, for professor, for promotion, they have given both for direct recruitment as well as for promotion. Both they have given, they have prescribed. For promotion, it is there. For direct recruitment, whatever AICT has prescribed, it is there. For promotion, you must have put in not less than 3 years of experience in the care of specific column 2. So if I'm assistant professor from 1992, I should be professor from 1995 based on my experience. Qualification and experience go hand in hand. They have to be viewed together. That's the meaning of this. Then before the single judge in writ petition which arose, which gave rise to this writ appeal in WP 33433, telling all these facts, both this and all that. And in this, the honorable judge, the court rejects my case, dismisses it, that I am not entitled because AICT has prescribed PhD and therefore you are not entitled. Then I went before the order on being spoken to. This order was on 22/6/2006, which is on page number 20 to 28, my lord. And in the final paragraph, the writ petition dismissed. Then I went before the honorable court again, pleading order on being spoken to. And there is an order again, 29, 30. And on 31, it can be read, my lord. It is made clear that if the two professors, that is D. Ramakrishna and P.M. Damodaran, have been extended monetary and other benefits aside from date of the appointment in 1994, then it will be open to the petitioner to make a request to management and the director taking the reconsider the matter, keeping in mind the benefit accorded to similarly placed professors. Whereupon the management and director shall examine the matter of fresh in accordance with law, and so on, and it concludes. And I have placed the appointment orders of these two professors, their approvals in the additional documents which I have produced before this court in this writ appeal itself. I'll come back to that, my lord. And after this, I approached commission again, and I went before the honorable High Court in review petition also. And the order of review petition is on page 32 to 34, my lord. And the last paragraph on page 34, although petitioners sought to add other grounds that are otherwise available only in appellate jurisdiction, this review petition being devoid of merit stands dismissed. However, this order will not come in the way of the respondents considering petitioner's representation, if any, in accordance with law. This is where he concludes. Then I go before the commission because government can do it, but it is not doing it. Though the court is giving them ample opportunities at every stage to reconsider, to relook, have a relook at it. Then I went before the commission once again. Then the commission passed orders in my favor, and all the additional documents are produced into this particular writ appeal. I will just take some time. I mean, few things to be submitted. Here, the first is referred to the additional documents which are submitted. Page number 12, additional documents. Official memorandum 21/4/1994. The appointment order of one professor, D.S. Ramakrishna, assistant professor in Department of Electrical Engineering, promoted as professor on 21/4/1994.
Document number?
Document number. Document number one, my lord. In which three documents are there. One is 21/4/1994, 15/1994, and approval 10/12/1997. Three documents as document number 1. 12 to 18.
Yes.
On page number 12, official memorandum, one Dr. D.S. Ramakrishna, assistant professor, is promoted as professor without a PhD in the year 21/4/1994. He does not have a PhD, but he is promoted. One more case, my lord. Next page. Page number 13, Sri Damodaran, not Dr. Damodaran, Sri Damodaran, assistant professor in the Department of Civil Engineering, promoted. His date of appointment order is 15/7/1994. Both are appointed without PhD. And in approval 10/12/1997, next page, my lord. English version, page number 16. Damodaran and Ramakrishna, the approval says that their appointment as professor will be counted from the date they reported to duty. That is, they reported to duty on the same day the appointment orders were given in 94, before they completed PhD. No PhD was done by them, but their appointment orders were considered. After approval, no new appointment order was issued to them. That's the reason. Then, page number 19 and 20, when I approach the commission, our college takes a stand at the serial number 6 on page number 20, my lord, last paragraph. Since you are a granting aid employee, you are requested to approach the government with respect to your grievance. Whatever the government takes decision, the same will be complied with. The college takes a stand that we have no say in this. If whatever government says, we are ready to comply with. Also, on page number 23, my lord, and again, after the commission has passed an order, which is on page number 22, which is dated 8/2/2017 in the chamber of Honorable Member Kamalama, National Commission, about Sakesh Shamu, Professor BMS College, regarding promotion. I would read this and read page number 23, my lord. Page number 22. The commission observed that the office memorandum 15/7/94 and 21/4/94 promoting Professor Damodaran and Ramakrishna respectively were not withdrawn at any point of time and was enforced till the retirement. Their promotion was approved in the year 1997 and given effect to from their date reporting to duty. The two professors reported to duty in the year 1994 itself, and they obtained their doctorate degrees only in the year 1995. Payment of pay and allowances to the promoted cadre otherwise does not confer any right upon the BMS College Authority or the government of Karnataka. The payment of pay or by way of executive order and their only consequential benefits flowing from the promotion. Such executive order cannot be taken as shelter for denying promotion. Petitioners legitimate right to be promoted as professor from 31/3/1995 with all consequential benefits. It was reported that even in the service register of PM Damodaran, the office memo number is not mentioned, which is a glaring irregularity maintained in the service register. Further insertion of paragraphs in different handwriting can be noted. So when this order from the commission came, the recommendation, college again takes a stand on page 23, my lord, where it says to discuss on the directions of the commission, so and so. There they take a stand as per recommendation for the proceedings for the National Commission for Children's Cause dated 8/2/2017. The Council of Trustees resolved to propose and send Sakesh Ram's case to the government for consideration. College is leaving it to the government to decide. And the next record note, which is 11/9/2017, my lord, page number 24. Again, the commission reiterates its stand, and I would like to read the last paragraph only, my lord. The commission therefore recommends that the BMS Educationals has sent a proposal for giving the promotion and other constitutional benefits in accordance with the recommendations of the commission. The state commission should accord necessary approval for the promotion to the petitioner from 1995 as per system. As a consequence of promotion to post of principal, BMS College of Engineering. Therefore, the college authority should issue the order of promotion to the post of professor 31/3/1995 and principal immediately, as the commission has already heard the matter and passed its recommendation in the previous record notes, and so on, so all of that. So this order 11/9/2017 was challenged by the state government before the Karnataka High Court, before the single judge. And on 5th September 2019, in writ petition 12782, an order was passed dismissing this recommendation of the commission. I go before the division bench in writ appeal 3821 of 2019, and on 21st day of October 2019, there was an order setting aside the order of the single judge. And in the order portion, I would like to read, it talks about the powers of the commission, Article 338, etc., and all of that. And finally, accordingly, we passed the following order. The impugned order dated 5th September 19 in WP 1278 is therefore set aside. The state government will consider the recommendation of the commission incorporated in Act 8 and take appropriate decision on implementation or otherwise of the said commission as expeditiously as possible. While taking a decision on the state commission consider relevant factors, including judgment relied upon by the learners or additional government advocates. Accordingly, the appeal is disposed of. Yes, my lord. Then I go before the government and submit my application to consider my case because everything is in order, therefore, to the needful. Then on 17th January 2020, the government considers the writ appeal order and passes a proceeding, which is dated 16th January 2020, in which throughout the proceeding, they mention about the promotion by CAS, cadre advance scheme, CAS scheme. They don't talk of the regular scheme as per the C&R rule. The entire proceeding talks about only CAS promotion, which is not my case at all, and they reject my case. Just to make me go again another round of litigation, then I immediately go before the Principal Secretary to the Government Social Welfare and seek clarification because they have known my file, and there is a DO letter from the government that rectify this. Even then, they don't do it. And I go before the Legislature Committee, Assembly Chairman, SC Welfare Committee, Karnataka Legislative Assembly. I submit my application there also. They consider. They send it to the Social Welfare Department to go detailed and come out with a statement. There they have done a thorough research of 2 months, going through my documents once again, and they write to the higher education again once more, on 16/7/2020.
We'll continue after the break.
Yes.
You don't have any objections. What 65? No, not in a hurry, right? All right, 65 list, praise learned counsel for parties jointly pray for adjournment. List after ensuing summer vacation.
Hello, court officer. ಸರ್ ಇದು 17th ಮ್ಯಾಟರ್ ಲಿಸ್ಟ್ ಒನ್ ಇತ್ತು. 17th ಮ್ಯಾಟರ್ ಲಿಸ್ಟ್ ಒನ್ ಅಲ್ಲಿ ಅದು ಹೇಳ್ತೀರಾ ಸರ್ ಸ್ಟೇಟಸ್ ಏನಿದೆ ಅಂತ? ಅಪಿಯರ್ ಆಗಿದೆ, ವಿಡಿಯೋ ಅವಾಗ ಬ್ಲಾಂಕ್ ಔಟ್ ಆಗಿತ್ತು. ಸೊ ಐ ವಾಸ್ ನಾಟ್ ಏಬಲ್ ಟು ರೆಪ್ರೆಸೆಂಟ್ ಆಕ್ಚುಲಿ, ಬರೀ ವಾಯ್ಸ್ ಮಾತ್ರ ಬರ್ತಾ ಇತ್ತು. ಕೋರ್ಟ್ ಆಫೀಸರ್ ಇದ್ದೀರಾ? ಹಲೋ, is there, I guess. ಸರ್ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಇದ್ದಾರಾ?
ಇದಾರೆ, ಹೇಳಿ
ಸರ್. ಇದು 17th ಮ್ಯಾಟರ್ ಲಿಸ್ಟ್ ಒನ್ ಅಲ್ಲಿ ಅಪಿಯರ್ ಆಗ್ಬೇಕಾದ್ರೆ ವಿಡಿಯೋ ಬ್ಲಾಂಕ್ ಆಗಿತ್ತು. ಅದೇನ್ ಸ್ಟೇಟಸ್ ಆಗಿದೆ ಹೇಳ್ತೀರಾ ಸರ್ ಸ್ವಲ್ಪ?
ಏನೋ ಫೋನ್ ಮಾತಾಡ್ತಿದ್ದಾರೆ, ಆಮೇಲೆ ಮಾಡಿ ಒಂದು ನಿಮಿಷ. ಫೋನಲ್ಲಿ ಮಾತಾಡ್ತಿದ್ರು.
ಓಕೆ, ಹಂಗೆ ವೆಯ್ಟ್ ಮಾಡ್ತೀನಿ ಸರ್ ಹಾಗಾದ್ರೆ. ಸರ್ ಸ್ವಲ್ಪ ಸ್ಟೇಟಸ್ ನೋಡ್ತೀರಾ 17th ಮ್ಯಾಟರ್ದು? ಕೋರ್ಟ್ ಆಫೀಸರ್ ಇದ್ದೀರಾ? ಅದು ಇವಾಗ ತಿರ್ಗಾ ರಿಟರ್ನ್ ಬಂದಾಗಲೇ ನೋಡ್ಬೇಕಾ?
Yes. Sometimes that's not now. Just fine.
लैंग्वेज में आप ले आए
Please don't go. Okay, ನಾಳೆ ನಾವು ಸರಿ ಓಕೆ
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಇದೀರಾ?
ಅದು ಕವರ್ ಕೊಡಿದ್ದೀನಿ ಸರ್ ಹಿಂಗೆ ಕೊಡೋದ ಮ್ಯಾಕ್ನಾಗೆ ನಮ್ಮ ಕಾರ್ಪೊರೇಟ್ ಆಫೀಸ್ ಹಿಂಗೆ ಕೊಡೋದ
ಏನೋ ಹಾಕೊಂಡು ಹೋಗೋದಕ್ಕೆ ಏನಾದ್ರು
ಅದಕ್ಕೆ ಅಲ್ಲೇ ಇದ್ದಾರೆ ಅಡ್ಡಿ ಪಡ ಏನೋ ಗೊತ್ತಿಲ್ಲ ಅಲ್ಲಿ ಇದ್ರಲ್ಲಿ
Court officer? Court officer?
ಎಸ್ ಹೇಳಿ ಸರ್.
56 ಸೀರಿಯಲ್ ನಂಬರ್ 56 ಏನಾಗಿದೆ ಅಮ್ಮ? ಅಡ್ಜರ್ನ್ ಆಗಿದೆ ಮತ್ತು
ಸೀರಿಯಲ್ ನಂಬರ್ 56 ಪಾಸ್ ಓವರ್ ಆಗಿದೆ ಸರ್.
ಪಾಸ್ ಓವರ್. ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು.
ಹಲೋ, ಕೋರ್ಟ್ ಆಫೀಸರ್ ಇದ್ದೀರಾ?
Last matter note 72. We will take up. There is one partnered matter.
Please, please, all of us are in.
Yes. Great. That all is over now. Conclude what you want to say.
In every place, wherever possible, I have agitated my rights. And from the information of the court.
Hey, Mister, please understand what we feel, whatever we have heard from him. He can't formulate the points. But the point which probably what he's trying to contend is, you will have to answer 3 questions, please. The order dated 17/9/2007 passed by the division bench, by which it was held that his seniority is to be counted on the post of assistant professor with effect from 31st March 1992 has attained finality, right?
Yes.
So he is entitled to the post of assistant professor with effect from seniority with effect from 31/3/1992. This order has attained finality. Second, that whatever regulations have been prescribed by the AICT, these regulations provide for this qualification of PhD in that is his case. He has not said so. That's what he is trying to read, that it is for direct appointment and not promotion. Probably what he wants to contend, that his case is a case of promotion. Therefore, requirement of PhD does not apply. And that commission is concerned, that we are not convinced, it's only recommendatory nature. They can't have any power to issue directions. So he is repeatedly telling us, I approached commission. That's only recommendatory, you have to consider. Now, that's it, Mr. Anything else?
And that qualification and method of recruitment.
So you say that it applies only case of direct appointment to the post of professor, right?
Yes.
Therefore, it does not apply to your case.
Yes.
And therefore, their action of assigning seniority with effect from 6/5/2013, it cannot be sustained. 16/3/2006. The day you have
not from the date of my acquiring PhD, but from the date when I am eligible to become professor.
So when you became eligible to according to
31/3/1995.
Eligible?
Yes.
But who has appointed you?
Lord, as per C&R rules 1987.
No. See, Mr. Eligibility is different, and this thing giving promotion is. When have you been appointed?
Yes,
to the post
I have been appointed from
promoted
from 16/3/2006. I'm already promoted, man.
Where is that?
I'm already promoted.
When?
As professor.
Where is that office? Where is that order?
That was the
date of order
24/1/2017. They have passed this order based on the approval of the DTE and the order of this Honorable High Court in 33433/2013. That from the date you have obtained PhD, you are eligible. Like that, they have passed an order.
All right.
And that is why I am contending that.
Where is according to you within 3 years you can be appointed?
Yes.
Become a please understand. Right? Constitution provides that an advocate who is enrolled. We are giving you an example. Since you are arguing this thing, we want to convey our point. That's why we are giving the example of a legal profession. The Constitution provides that any advocate who has put in 10 years of practice is eligible to become judge of the High Court, right? So that doesn't mean that any person who immediately completes on completion of 10 years files a petition saying that I should be appointed. So eligibility, becoming eligible, he is eligible, but eventually what will matter is when he is appointed.
Yes.
So got it?
Yes, ma'am. In this case,
now,
in this
so
case.
how do you, what basis you
Yes.
say that
In this case,
95
ma'am,
you are, and
I'm
you may have
already-
become eligible.
eligible and I am already professor. I am already promoted as professor as per C&R 1987.
No, but you were promoted in 2017, right?
No.
With effect from 2006,
Six.
because he attained PhD in 2006.
No, but when he was promoted.
My lords, he was promoted. If your lordship sees the impugned order, internal page 11, there was a direction to us.
Where is the order? I mean, he told us, right? 24th January.
Please.
Before that, he has not worked as professor.
No, my lords.
Huh?
No, my lord.
Where is this, Mr.? What he's saying is 3 years. Where do you get it?
My lords, that he relied on C&R rules to say, because that was his prayer in the writ petition that he filed. He said that I am entitled to retrospective promotion from 95 onwards is his case. We, my lords, appeared there and said that insofar
No,
as
first of you got it right. So first of all, you have to tell us this issue has attained finality that he is entitled to count seniority on the post of assistant professor with effect from 31st March 1992.
Please,
having been upheld,
yes,
right? So these is entitled 31st March.
Yes.
Now, how he becomes under
on
which
1/10/2009, my lords, we notified that his seniority, because we obeyed the Honorable Court's order, and we fixed it from 31/3/1992. Thereafter, my lords, he makes a representation that because of C&R rules, C&R rules prescribe that 3 years is sufficient of working as an assistant professor. Therefore, I have to be promoted as a professor.
So is he, whether his claim is under the
C&R rules.
C&R rules? No, but whether he is promoted under the scheme framed by AICT.
AICT. What we
so AICT, if you have this thing promoted him,
please,
then how do you? He says that the requirement prescribed therein is not for promotion. PhD is only for this thing.
See,
and where is what basis you have to assist us, Mr. Please tell us under what provision he says 3 years. C&R rule saying doesn't mean where is the rule? Which rule says 3 years?
In C&R rules, my lords, there is a rule 2B. If your lordship sees page 131.
It's there. C&R rule.
Page 131. He's annexed the rules.
Annexed. You know one. Yes.
In the page. Page 131.
Karnataka Education Department.
Please. This is the C&R rules. If your lordship sees 2, method of recruitment and minimum qualification. 2A, my lords, I won't trouble your lordship. 2B, if your lordship sees, post for which All India Council for Technical Education has prescribed recommended minimum qualification, the same qualification shall apply to these posts in respect of other posts not covered by AICTE. The qualification as prescribed in these rules shall apply. And if your lordship sees, this was notified in the year 1987.
Yes.
The learned single judge, my lord, says at internal page 8.
So here, so 130, come to 133.
Please.
Professor, College of Engineering.
Yes, please.
For promotion must have put in not less than 3 years of service in the cadre specified in
Column 2.
Then
For direct recruitment, it should be in a particular manner.
Separately, they have given.
For promotion also.
Yes.
Then for promotion 3 years. So that's why he says that next day, immediately after completion, is entitled to appointment.
Yes.
But get it now.
The institution.
This is 130.
Yes. The institution has always been following right from, because AICT, this was in 1987. AICT, my lords, notified in 1989. 164, your lordships may kindly see.
AICT notified in
1989. Yes.
There, my lords, the
page 164.
164 is the notification of AICT. Relevant page at 178 for the post of professor in Matrimonial.
79.
Please.
Yes.
Item 3, professor. Qualifications. PhD with first class degree at bachelor's or master's level in engineering technology, or PhD degree with first class MSc in appropriate branch of teaching, post in humanities and science. PhD is one of the requirements.
Yes.
That is what is being followed by the institution from 1989.
But he says that this is applies to direct recruitment.
Yes, please.
Where do we get
the difference, my lords, is if your lordship sees the finding of the learned single judge on this aspect.
So what is, please you explain, then we will go to finding.
Please.
Whether it applies to direct recruitment or promotion as well. Where do you get it?
Page 168. The rules prescribed, my lords, is for the post of professor itself. And it is not for the mode of selection, my lords, by either by way of direct recruitment or my lords promotion. It does, AICT rules does not look into either of these aspects. They look at the post in particular. Therefore, my lords, we had followed that for the post.
You need to adopt this qualification. Where have you adopted? Government has adopted by an order.
Yes, my lord. Yes, my lord. Page 1. State government has adopted, my lords.
We are trying to find out, Mr. I mean, we will hear you. Yes. Where you are not coming because it requires a legally trained mind, right? You may be an expert in civil engineering, we may be zero, but arguing a point of law requires an expertise.
139 page, my lords.
139. 139. It is adopted, right?
Please.
So, lecturers, assistant professors, principals. The government order dated.
It is government order dated, my lords, 1990. 1st March 1990.
Yes. So, what's your submission there?
My submission, my lords, would be that insofar as the post of professor is concerned, right from 1989, we have, my lords, followed the AICT rules. The institution, in working together with the government, has followed the AICT regulations.
He has been, how has he been appointed? By way of promotion or direct appointment?
Initially, my lords, he was appointed as a lecturer initially.
No. The post of professor, under which quota?
But we have promotion, my lord, because in 2006 he got his PhD. The minute he got his PhD, we promoted.
No, but you have issued an order on 24th January 2017.
That is because of the order impugned, my lord, says that there was a slight error insofar as his date of obtaining PhD was concerned.
So your second submission is that he has been promoted.
He has been promoted.
Promoted.
He has been promoted from the date of obtaining PhD.
What is, you read the qualification once again, please.
For AICT, my lord.
179.
Please.
PhD with first class. Please go ahead. Please.
PhD with first class degree at bachelor's or master's level in engineering / technology, or PhD with first class MSc in appropriate branch for teaching posts in humanities and science. That may not apply, my lord, because this is a technical education. So item 1 will apply. Roman 1.
What about 2?
2 is 10 years experience in teaching industry research, out of which 5 years must be at the level of assistant professor or equivalent.
No, so both these conditions have to be fulfilled.
He fulfills both the conditions the minute he obtained his PhD. Because his assistant professorship should be counted from 92 is what this honorable court had said. So therefore 92 to 2002, my lords, he's completed that 10 years also. And 2006 he obtains his PhD. Therefore he satisfies both the criteria.
2002 teaching criteria, this experience.
Yes, but 10 years he would have completed in 2002.
All right. That's it.
Please.
Oh, anything
My lords, so far as the other two professors which he had mentioned,
they did not have the PhD degree.
my lords, if your lordship sees the additional documents that he has produced at page 12,
who are the candidates? What are
two candidates, my lords, one by name D.S. Ramakrishna and one by name P.M. Damodar. These two candidates, my lords, if your lordships would to see the official memorandum, we say subject to approval of administration committee or board of management and director of technical education, we had promoted them. My lords, that may have been
no, but whether they had the PhD qualification, that's the contention. They
yes,
did not have.
that is what I am coming to. If your lordship sees page 14, in the translated page at 296, 296 minutes, sorry.
96.
The English version.
Yes.
And at page 297, if your lordship sees.
Hey, what is it? Please tell us.
I'm only trying to say, my lords, that the government approved their promotion only from the date on which these two professors obtained their PhD.
So it's simple,
That's,
right? I mean,
that's
approved promotion from the date of PhD.
them obtaining PhD. They obtained PhD in 95.
Where is it?
My lords,
96.
Page 297. Date of report to work, they say 25/3/95. That's the date on which these two professors at item 1 and item 3. These are the two professors in question.
No, but where is it that they get PhD on this date?
In fact, we have passed. It is here. In additional documents. Page number. Page number. Page 17, 18. English version. Additional documents.
That's what he's referring to. 296 is
Yeah.
60. Oh.
That they obtained PhD.
But where do we get it that this is the date?
My lord, I have not produced that. But if your lordship sees page 300, this is the letter addressed by us to the appellant.
Yeah.
At paragraph 5.
Yeah.
As regards the two professors in question, Dr. So-and-so and Dr. So-and-so,
What
were
is
appointed
this?
by the college in the year 21.
What is 300, Mr.?
My lords, this is the additional documents that the
No, what is this document?
Serial numbers are different.
No, we have got it, but what is this document? You
This
should
is the
tell us.
document, my lord, in the
Sent to
impugned order.
Petitioner.
It is addressed to the appellant.
Ah, yes, appellant.
It is addressed to the
So that's what you should tell us
Please.
before reading.
Please.
2110. Yes.
This was in compliance of the order passed by these learned seniors. Respectively, subject to approval by the Director of Technical Education, our records reveal that the professors in question obtained their PhD on 16/12/95 and 25/3/95. Also, please note that
16/12.
Please 16/12/1995 and 25/3/1995. Also, please note that their appointments being made subject to approval by the Director of Technical Education. The said approval was made on 10/12/97.
So your stand is that they have been granted promotion with effect from
The
date
date
of obtaining the PhD degree.
Please. Please.
That's all. Yes.
I have submissions.
Says, my learned friend says that AACT qualifications for professor at page 179, which is also there on 153 passed by the state government, same thing. For professor, PhD qualification is necessary. The same government order says that the recruitment for that qualification has to be by open selection only, not a promotion. I'm not contesting that PhD should not be there, but it is for open selection, not for promotion.
You have got it.
Yes.
That's what we told
Yes,
him.
ma'am. Yes,
So his submission is that these regulations do not, they only prescribe a qualification for the post of professor, irrespective of the mode of recruitment, whether it's by appointment.
That is not.
That is his submission list. So that's what we will decide.
Yes, madam.
So supposing if we hold
That's
that the requirement contained in this regulation does not apply for promotion and you have been promoted, you succeed.
Exactly.
Simple.
131, my lord. Method of recruitment and minimum qualification. 131. C&R.
131.
Page number 130. Serial number 2, my lord. Method of recruitment and minimum qualification. They go hand in hand. They are not separate. They cannot go separately. There are several Supreme Court judgments in this regard. What they say is PhD, whatever ACT says, it applies for promotion as well. That is what they say. It is not true. It is not correct. Method of recruitment and minimum qualification go hand in hand. That's my submission. ACT, whatever it submits, it is applicable for open selection. I have I'm not contesting that. But for promotion, C&R applies. There itself, they say 2B. In respect of other posts not covered by ACT, the qualification as prescribed in this rule shall apply. That is C&R rule shall apply.
Where have you read?
The same page number 131, my lord. B, 2B.
2B.
Post for which All India Council for Technical Education prescribed recommended minimum qualification, the same qualification shall apply to these posts. In respect of other posts not covered by ACT, the qualification as prescribed in this rule shall apply. Because C&R is very clear on promotion and direct recruitment separation. They have very clearly bifurcated the both the mode of selection. Mode of selection and qualification go hand in hand. They cannot be separated. This is my contention. Method of recruitment and minimum qualification go hand in hand.
One thing you will have. See, another question which arises is that these rules, C&R rules have been notified on 31st August 87, right? At that time, revision, this scheme was not there. So therefore, what it says, 2B, that there was no prescription.
There was no prescription.
No
That's why we
prescription there for
followed
3 years.
Yes. But 1987, when this C&R rules were in force, there was no AICT regulations. Then, my lords, in 1989, AICT came up with its regulations.
That's all. What will be the effect on the rules?
Then, my lords, we will follow AICT. That is what the 2B also says. Posts for which AICT has prescribed recommended minimum qualification.
This, the 87, they could not have said
They
that
could not
some time in
It
future.
did not have. It did not have.
At that time, it did not have.
It did not have.
So therefore, why it should not be presumed that this qualification will apply?
Because in 2 years later, they notified, AICT notified. And he, my lords, became eligible according to him.
What happens to this rule then?
For which AICT has not notified, my lords, this rule will apply. That is what the second portion.
For this rule to be to operate, the prescription should have been in force as on 31st August 1987.
87.
This can be the, I mean, we are just trying to understand,
Please.
broadly discussing,
Please.
right?
Please.
So there was no prescription.
At that point of time.
So, right, 89 scheme is notified by AICT,
Please.
right?
Please.
What is the effect
Effect, my lords, will
on
be
these rules?
on these rules, my lords, insofar as those posts which are not covered under these rules, then AICT, that is the latter portion of 2B. If your lordship sees the latter portion of 2B, the same qualification shall apply to these posts. In respect of other posts not covered by AICT, the qualification as prescribed in these rules shall apply.
So therefore, that's why what is eventually it turns down, it boils down to this. What is the effect of subsequent notification of revision of this thing?
Then, my lords, what he submits
by the AICT.
AICT.
These rules exist, right?
He admittedly, my lords, wants it from 1992 because that is now attained finality because of the order of the division bench. He wants it from 1992. As of 1992, if your lordships would see, the AICT rules were in vogue. 95. So therefore, because it was
No, he wants it from 95.
Even better, my lords, it will endure to my case. Because 95 would mean that the AICT rules were still prevalent. And state government also notified the AICT rules. So therefore, we have followed, in fact, from the 1989 itself, all posts to the post of professor has been done following AICT. We have never looked at.
That's all right. What you have done is all right. But we are asking you, what is the effect of these rules? Then, I mean.
So whatever posts, my lords, there are various, it includes various other posts. In fact, DT also comes under this C&R rules appointment. If your lordship sees, there are various posts which are there. Humanities, science, all that, my lords, is covered under C&R. So AICT, when it prescribes lit rules, it will look at only technical education.
1 minute. Don't be in a hurry. We will hear you. Let it complete.
So AICT rules, my lords, will come out only with technical education. They may not include DTE, for example. They may never include DT.
That scheme is under any statutory provision.
The C&R rules, my lords.
AICT.
Under the statute, my lords.
The Act.
Yes.
Which provision? Because it doesn't say so, I think. Let's see where the AICT.
That was amended next in 2008 only. After this, they have amended. That came only in 2008.
Oh, where is it? Which page?
But AICT rules is at page 164.
154. At 164. Ah, yes. There are. This is a scheme of revision of pay.
Yes.
Falling under the purview.
Thereafter, there is an appendix, my lords, at page 167.
Where is the AICT Act? There is an act, right? AICT Act. This is the scheme.
Also, it says it is for open selection. C&R was amended in 2008.
1 minute.
Till then, this was in force.
1 minute. These rules, Mr. 1987 rules applies to grant-in-aid institutions, right? There's no dispute about this.
There's no.
What is under which provision the scheme has been enacted? Which statutory provision?
I'll come back.
That is the question, Mr. If there is a general provision, subsequently in exercise of powers, subsequently if a specific provision is made, to that extent that should be the you should have brought this case law and this proposition. And should have told us this is the statutory source. This we don't get it from it's a scheme.
It's a scheme from
a scheme means whether it has a statutory force.
So because my lord, state government accepted it. I understand.
We are required to decide it, right? We cannot say state government has accepted. State government can do anything. But we have to deal with the question, legal question which is raised by him. So what is how his rights get curtailed under consideration under the C&R rules by this scheme? That's the question.
Right.
Oh, thank you. We are right for a change. Rarely people say otherwise. He will say, I am not right. Because we are agreeing with you tentatively. It's a broad discussion, Mr. We are here. We are not against you or in favor of him or anybody, vice versa. We are trying to find out a solution to this legal problem. We are trying to understand what is the effect. So, Mr.
Please, one more submission.
Tomorrow.
Please.
We are no, we are not concluding it. We will come up tomorrow. We will hear you.
Fine.
Party in person heard this thing. So and so for respondent. Learned counsel for respondent prays for a short accommodation in order to enable him to examine the effect of the scheme notified by AICT wide on 28 to 1989 as regards the Karnataka Education Department Service within bracket Technical Education Department bracket close recruitment rules 1987 are concerned. As regards the provisions of so and so are concerned. So far a comma insofar as it pertains to appointment to the post of professor. Place tomorrow. What day after? Tomorrow. What is there?
No, if I may have to look a little deeper into AICT, my lords, it's not easy to get the regulations so easily. I have to check it online.
You have placed it on record, right? You are relying on this. If it is a statutory, please understand. And the simple question is, if it has a statutory force, then perhaps you can say, though you are not argued, but you can argue that specific provision, the general provision is impliedly repealed to that extent that you can argue. If it is not so, then he is right under the rules. How at least it arises for consideration after 3 years. We are not saying that he is entitled, but 1995 he becomes eligible.
I only have to substantiate this scheme.
So you are relying on this scheme, right? Yes. And another submission, you find out this thing that is this, like you are arguing that it has nothing to do with this thing. He is saying that this applies only to appointment, case of an appointment and not promotion. I'll place it tomorrow, please. 24 hours are enough, I think. Which day? Or what day after? You didn't argue anything, we have not heard you. Huh? Huh? You did not ask for an adjournment. He is arguing. We have posed the question to this thing, Mr. What is this? No, tomorrow it will be concluded. Don't worry. We have to conclude. So it's not that if you have until unless you have found out that tomorrow is going to be a holiday, so it can't be concluded. We don't know. This is the question. Please understand, it's a legal question. Your officers cannot tell you. You have to study it. Understand? Whether your officers will not tell you whether it's a statutory scheme. If you call somebody, he will not tell you. You will have to burn the midnight oil to find out. Simple. Officers cannot tell you. Who are you? Great. All right. Tomorrow. Which was the case, Mr. 70. No, this was which case? 64. Ah. 1 minute, they are mentioning one case. They are mentioning one case. 72. Yes. Yes, we are taking. Where is this? Yes, please. Yes, madam. We are asking you. You are 66. Please wait. We don't know how much time will it take. So, have you prepared a synopsis, Mr.? So give it. Oh. Synopsis. Give it, Mr. Yes.
Properties. The appellant,
Mr. Thomas, just keep that in the party.
appellant is a nursing home, a Manasa nursing home in Tirthandi. It's a psychiatric nursing home. And first of its kind in Karnataka, rural Karnataka. It was started in 1981. And Dr. U. Arunachala is the proprietor of nursing home.
Yes. Yes.
The reaction of both the
Yes.
judges.
Yes.
The second respondent is a trust located in Car Street, Tirthandi town. So for better understanding, I have produced the commissioner's report submitted in the writ petition in the course of the writ petition. Is one of mine. The right side of the sketch, the portion which on which construction was undertaken by the respondent under construction building. On the left side is my nursing home building which has the nursing home. The commissioner's report was not objected to in the course of the request. When it was submitted, commissioner's report showed that there was violation of setback in this section.
And what happened? What was the order under challenge?
Yes.
Just briefly give us the facts also. We don't.
Yes.
What is it? What was under challenge before the single?
Before the non-single bench, we challenged the construction plan, building without leaving setback. In setback, and directly onto my compound wall. And the prayer in the reflection was, sheer writ of circular or any other appropriate order, declare that the action of first respondent in allowing construction of the B-schedule property by respondent without obtaining licenses illegal. On the date petition was filed, they had not even obtained the license for construction of the building. Issue of violation restraining respondent was to from putting up construction in main portion of the property described in Schedule B property.
The grant such as the
So, right, I mean, it was found that he has not even obtained any permission and then they started raising construction.
and
That
Lalit
was
Singh
violation and
as accepted.
Lalit Singh accepted it and said that since only this thing plinth level is not even plinth level, so therefore no this thing demolition. You are agreed by that. So it should have demolished.
It should have been demolished. One.
What is it? What is the construction?
The construction is of a larger.
No. What was the stage of construction?
Foundation.
That's what it is.
At the stage of foundation, I complained to the municipality.
So these are three photographs, right? G6,
Yes.
Mr. Bhupati.
These are the photographs.
So your grievance is that all this should have been demolished.
Pardon?
This should have been demolished.
It should have been demolished.
Yes.
Because it's against the setback.
Yes.
The Lalit Singh has accepted it.
Accepted, yes.
He has also accepted that without license he has started construction.
Yes.
But so far as obtaining license is concerned, he says, I will put exemplary cost to the second respondent, namely the cost of removal of the illegal construction so far. That should be paid to the municipality. It is the municipality which has colluded with the second respondent in allowing him to construct without the license. Because I have written two letters, one in May, one in June 2021. They didn't take any action. So, but they were rewarded for not taking the action. They were rewarded by saying that the cost of demolition shall be paid to the municipality. And this is stated to be 3,600. That has been paid to the municipality. Cost of demolition is stated to be 3,600. That has been paid to the municipality, which has erred in not demolishing it or stopping it from proceeding, construction from being proceeded with. Whereas municipality has been rewarded by giving them cost.
Yes.
Now I would like to read the order.
It's in your favor, right?
No, it's against me.
What again? The fact that illegal construction was raised without any permission has been accepted.
Demolition is not an order.
That's the only thing, right?
Demolition is not order. That is what you have seen.
Paragraph 14, 15.
I'll read from paragraph. Seven of the. I given my anxious consideration. Page 14. Anxious consideration to be sufficient made by the respondent, the respective learned counsel and produce the material on record. The aforesaid narrated facts, though in brief, being not in dispute, need not be reiterated. The issue in this is whether second respondent has undertaken construction in violation of law or without obtaining building license. This court, in order to resolve the dispute, directed conduct of inspection of the disputed area. The inspection report is also filed by the municipality on 27/2/2021. The perusal of the inspection report indicates that the construction undertaken by the second respondent is violation of the norms without leaving setback in a residential or commercial premises as found in Annexure B. The Mahazar and the sketch appended would clearly demonstrate this fact. The Mahazar in the second circle, therefore, it is for the second respondent to undertake such construction strictly in accordance with building bylaws and norms prescribed for leaving setback in a particular construction, be it residential, commercial, public, and semi-public. Therefore, violation of setback is agreed by the NRC. The other issue is with regard to beginning of the construction without obtaining appropriate license. Second respondent has filed a statement of objection, wherein second respondent admits that an application was made on 5/7/2021. Yes, my complaint was in May 2021. But sanction of the plan and the first respondent town panchayat has granted building license on 9/8/2021. It is a further admission of second respondent started construction right in front of the existing building on the same line and in alignment and has only dug pits, erected pillars. The government's statement of objection relevant for consideration of the present case are as follows. It is extracted, the portion of the statement of objection. Thereafter, the learned single page has said the aforesaid extracted elements made in the statement of objection, if read in juxtaposition with the photographs that are appended to the petition, clearly indicate that the construction in property has begun even before the building license was approved. Requisition for grant of building license, according to the objection, is submitted on 5/7/2021 and the same is approved on 9/8. Before even requisition was also given after the construction commenced. The other building license that was granted earlier was not the present construction. The photographs reveal that the building construction had begun the construction of pillars and laying foundation in the month of June 2021. When even applying for grant of building license, second respondent ought not to have commenced construction of the building and during the pendency of the approval license before first respondent, the second respondent would not have continued with the construction. Therefore, on both counts, second respondent has violated the law. Then,
what was your when was your complaint made?
Complaint made was without setback.
When date.
Pardon?
Date on which complaint was made. There are two complaints.
There are two complaints. 81/5/2021, Annexure E-F. 81/26/2021, Annexure G.
When was the petition filed?
29/6/2021.
What is the prayer in the petition?
Petition was that
declare in allowing construction without obtaining is illegal.
There is no prayer. There is no prayer for demolition. There is no prayer for demolition.
Yes. Yes.
Yes.
The observation made by the single case is important notice. The first respondent town panchayat should not have turned a blind eye to the construction undertaken by in its vicinity and turned a deaf ear to the complaint registered by the petitioner, alleging construction being undertaken in violation of the law. The construction in the town panchayat area is dealt with on section 187 of the Act 1964. Section 187 reads thus: notice of new building. Before beginning the construction of any building or to alter externally or add to any existing building or to construct or reconstruct any project in projecting portion of a building in respect of which the municipal council is empowered by section 181 to enforce and removal of setback or to construct or reconstruct it on the municipal council is empowered by section 179 to give permission. The permission that the person intending to go to construct, alter or add or reconstruct shall give to the municipal council notice thereof in writing and shall furnish to it at the same time a plan showing levels at which the foundation and lowest floor of the building are proposed to be laid by reference to some level known to municipal council, and all information required by the bylaws or demanded by the municipal council regarding the limits, dimension, design, and ventilation and materials of the proposed building, and the intended situation and the construction of the drains, sewers, trees, water closets, cesspools, if any, to be used in connection with and location of the building with reference to any existing or projected streets and purpose of which the building will be used. Therefore, no construction or reconstruction referred to in subsection 1 shall begin unless and until permission for execution of the work is granted under this section. It is also not taken. My submission was in reference to this. The license obtained after the construction of building was itself bad in law, because you have designed it in some way. You are going ahead with the construction of the building. Therefore, after the construction, if license is obtained, either it should be demolished and he is asked to apply afresh and take license.
Supposing if a license is granted, the aggrieved person has any remedy under the Act? No. Aggrieved person has any remedy, supposing if license is granted to A and B is his neighbor and he is no remedy. Appeal must be there, right?
No. Appeal is not.
Oh, it's all right. Yes.
Appeal is not there.
Not there. Okay. All right. Yes. So yes, it is. The finding is in your favor. Your submission is that the learned single judge should have directed demolition. Order is in your favor, passed by learned single judge. The only portion is learned single judge should have directed demolition.
Demolition.
Huh.
Yes. Secondly, so far as appeal is concerned, I am not aware of the appeal provision. Even if there is appeal provision, this petition was entertained and order was made. At the initial stage, if the court had said you have recourse to alternate remedy, it could have proceeded with the order. But
Yes.
so far as this case is concerned, interim order was granted, and thereafter a commissioner was appointed and report was sought for. And to that report, they did not file any objection. I filed objection saying that limit is not shown properly. The setback limit is not shown properly by the commissioner. And we sought for fresh commissioner to measure the property afresh. Therefore, the court having written a detailed order in respect of violation of law, so far as the second violation is concerned, it does not do anything. And you see the outcome of this. The power is vested in paragraph 12, page 18. The power is vested in town panchayat to either grant or reject permission, license that is sought. Subsection 1 of 197 makes it mandatory. Page 27.
Yes.
187 makes it mandatory that before beginning construction of any building or to alter externally or to add to existing building or to reconstruct, the person intending to do shall give the town panchayat a notice thereof in writing and shall furnish to it at the same time the plan showing the levels at which the construction will be undertaken. Therefore, it is an admitted fact that second respondent did not even apply for permission or license to the town panchayat before commencement of construction or continued with the construction after submission of the application before town panchayat could approve. Violation of law is writ large in the case at hand insofar as it pertains to construction. The building that is now thought to be erected by the second respondent being erected in violation of law is required to be brought down by directing the demolition from the hand of the town panchayat. It is also to be noted that the construction undertaken by the second respondent is at the level of foundation and erection of pillars, and in the light of interim order granted by this court, second respondent has not proceeded any further. Therefore, this is a peculiar paragraph, as the learned judge also says. Therefore, in the peculiar facts of this case, in view of directing demolition by the town panchayat of the property belonging to the second respondent, I deem it appropriate to impose exemplary costs upon the second respondent, which would equal to the expenses that the town panchayat would incur for demolishing illegal construction taken up by the second respondent. This direction is to be issued in the peculiar facts of this case, as the construction is only at the stage of erection of pillars and foundation. Therefore, the town panchayat shall assess the expenses that would be incurred for removal of the demolition of the illegally taken up construction by the second respondent, which is admittedly the construction in violation of law at the cost of the second respondent. If petition is allowed, first respondent town panchayat shall assess the expenses that it would be incurred for demolition of the illegally taken up construction on Schedule B property by the second respondent and recover the same to the hands of the second respondent. The second respondent is at liberty to take up construction strictly in consonance with law, and the first respondent town panchayat shall ensure such consent. Now, the construction shall proceed in the same manner in which it was started earlier. As I said in my sketch to the commissioner's report, violation was there. So far as the construction is concerned, the learned judge said you pay the cost to the town municipal council, but happily proceed thereafter. Now, the court may kindly see the extent of violation. 3 inches the southern coast, the eastern coast, sorry.
Page 1. Page 1 you are referring.
Page 1. Eastern end, 3 inches. Actually, 6 pillars were there, he did not show it. Then at another stage, 1 feet 9 inches. As per the norms, it is 3 meters. And I have reduced it at annexure C. Page 44. Page 44. Third column, page 44, in the third column. Depth of site in meters. Over 9 meters to 12 meters. This comes under this column. The setback to the left is residential minimum 1 meter, commercial 1 meter, 1.50 meters. It's a hobby, this is a commercial venture, not residential. Or if it is public and semi-public, it is 1.50. So 1.1 meters at the left side, this becomes the left side. If we look at it from Car Street, from Car Street, left side 1 meter it has to be. But what he has left is what I have read now, just now, from the sketch. Sketch was not disputed by the other side. In this view, whether awarding cost to the municipal council which overlooked two of my representations, one in May and one in June. Is it justified in law? Is what this honorable court will have to say. One. There is another reason why it should not have been given. Kindly take the synopsis given by the respondent. Chronology of facts. Now, in the writ petition, I said the first building was constructed in November, and inauguration was made in November. Building was constructed in November, and inauguration was made in November. Can you see? 1st September 2018. This is where I made one mistake. The respondent number one sanctioned building plan for the construction of ground floor of the existing temple building after respondent number 2. Second, 12th November 2019, respondent number one sanctioned plan for the construction of first and second floor in the adjacent land within on this scheduled property. Now, from their own invitation, which was distributed in November 2019, it is very clear. Sorry, in this, yes, I have given the translation also, at page 47. The building was inaugurated on 22/11/2019. So, first and second floor of the building were constructed, and obviously, after construction, they have working plan. Plan was sanctioned, as the court sees, 12th November 2019 for first and second floor. The second column says 12th November. Now, inauguration is 22/11. There will be an attempt to misquote this at paragraph. Page 48. Page 48. This massive project is the invitation, English extract of the invitation. The massive project requires an estimated 3 crores of rupees and is being carried out on a priority basis. First, Hemalambi Samvatsara, Falguna Ashtami, 9/3/2018 at Suratkal Mokam, that's a different construction. Then was blessed by Sri Tirtha Swamigal. Then the Lakshmi Meena Shamma Kripada inscription from the palm has been completed and the work is then Sri Kashi will inaugurate Kashi Matadipati will inaugurate and bless Vastu on the occasion of Kartika Bharata, the anniversary of Vicarial Nama. The cost of each of these houses is rupees so and so. It is estimated that 15 lakhs if the servicer contributes the name of his family, his name will be preserved. On the eve of the 10th year celebration temple, during the Kartika Bahula Dashami on 22/11/2019, Sahasra Puja will be done by the Padam Puja Sri so and interested devotees can also participate in the Pravasya Puja. On this occasion, Sri Parama Puja Guru will lay foundation stone on the Sujindra Smriti Bhavana, a Vastu to be constructed in the name of Srimad Sujindra Bhavan. Tirtha should become an amazing Vastu and building. We are requesting most cooperation. Because the construction of building, it was inaugurated on 22, for which license was obtained on 19. Now this I misquoted as first floor, from the first floor. That was wrong. But for the second and first floor, the permission was obtained on 19th of November whereas the inauguration was 22/11/2018. So with this experience in hand, I did not give any complaint in regard to the first floor of the building. First building. Kindly see the photographs I produced at the commencement of the construction. Kindly see page 65 onwards. The second and third photographs reveal that no setback has been given. Left at annexure J4, J5 is the second building. Then at page 76, 66, J6, J7, J8. No setback has been left. And the building which I have said, the first building that is seen at the annexure J6. ನೋಡಿ ಅದರಲ್ಲಿ ಕಾಂಪೌಂಡ್ ಕಾಣುತ್ತೆ ಮತ್ತೆ ಬಿಲ್ಡಿಂಗ್ ಕಾಣುತ್ತೆ setback is built in. About 10 inches or so setback has been given. I did not complain against this portion because it was at the beginning of my property. The nursing home comes later. Now, page 10 of my synopsis. Seven of my synopsis. Construction of building under construction is the one. Next week I have highlights. There is no setback here. Again, also no setback for the second building. Very clear. Taper form. The taper form again. Another photograph. Again, it shows no setback has been left towards the southern coast, east, southern coast, western coast. And last one. Nothing on the right side is the nursing home, left side is the construction. So they have already put one floor, and second floor is about 2%. And in the commissioner's report, they changed their version in the writ appeal. Writ appeal, they said, there is an encroachment towards the nursing home. There is an encroachment of our property towards the nursing home. Let us agree that there is such an encroachment. If there is an encroachment, you must have it removed and then construct. You can't say my setback is in the other owner's property. You must have it removed and then go with the construction. No, they are disputing the compound as belonging to them. It is part of my sale deed. Sale deed shows that the compound belongs to me, but they are now claiming that the compound also belongs to them. So therefore, in the application filed for construction, they should have said that there is an encroachment towards the nursing home side. They did not say that. It is after the commissioner's report and when the final hearing came, and this order was made by the learned single judge saying that you have violated the setback norms, and also you have not constructed in accordance with the plan. In a writ appeal, they said no, there is an inquiry. In a writ appeal also, the commissioner was appointed. Commissioner gave a report, which is produced. Inspection report is there in the file. Let me see it. This report has been filed on 28/3/2022. This is the translation. About that matter, respondent number 1 respectfully submits that the translated copy of the report of respondent number 1 dated 31/1.
Where are you reading?
A memo was filed by the commission, first respondent, that is Municipal Council, and that is thereafter they filed translation. Translation is dated 28/3.
Thank you.
95.
Memo haki. Memo haki.
Yesterday. Yesterday they have may not be given. Giving a copy. There. Take a copy of the report. Yes.
I don't have the Canada document of the commissioner's report. There is a sketch appended to the commissioner's report.
We have got the spot inspection report.
Yes, spot inspection. I have fixed it along with my memo file today.
Karnataka Municipalities Act. Corporation. Yes.
I have appended it to the present synopsis.
This is like 31st March, right? 31st January 2020.
Fifth page part 5 of my synopsis. Page 5. Suddenly the distance goes up, distance of setback goes up. The property is the same. Suddenly the distance between my property and his property goes up. And his setback becomes smaller. Distance of setback becomes smaller, even though the building is the same. Buildings are the same. So this is the commissioner's report. To this commission report, my learned friend files objection, saying that it should be rejected and a fresh commissioner is to be appointed. Going by the sketches I have produced, it is undoubtable that setback has not been met. Even if a fresh commissioner should go, an advocate commissioner can see the distance, only that, to that effect. Distance between the present building and my compound. Submits I report the repetition, entire repetition will be disposed, can be disposed of, because till now it is a disputed question. But if an advocate goes, even as the respondent says it should be rejected. A cash commission should be appointed. Let him go and measure the distance between the present construction and my count and submit the report to the court. There ends the matter regarding setback. The action to be taken thereafter can be decided by this.
That's all. Thank you. Yes.
Okay. One submission is below, page 33 of the appeal memo. Lordships, see paragraph 6 of the writ petition. Paragraph 6 of the writ petition on page 33 of the appeal memo. I'm reading about 7-8 lines from the bottom. However, the second respondent line paragraph 6 last 7-8 lines. However, the second respondent tried to claim his gate. However, the second respondent tried to claim the gate as public road and tried to bring vehicles, and at that stage, a suit OS number 10 of 2020 was filed by the petitioner for the grant of injunction order restraining the respondent number 2, passing through the taking vehicles through the private path running from the western side and entirely belongs to the petitioner. Injunction has been granted by the learned single judge. The said suit is pending consideration. So the whole dispute is that there is a pathway between my property and his property.
Not in this writ petition. Not in this writ petition.
Let him.
I have not stated anything about the public road or lane. Somehow or the other, these irrelevant things are being raised up.
Please go ahead. You know
that's what but I can't.
Go ahead.
I'm senior. No, I am saying, Lord, OS 10 is already filed. So all the disputed questions of fact, everything, Lord, can be adjudicated in that. They have disclosed that in the writ petition very fairly that there is a suit filed. And Lord, kindly see the next para 7. When matters stood, thus respondent started construction of the western side, so and so, so and so. Then your Lordship sees para 12. Just Lord, connect these two dots. Para 6 and 12. It is under circumstances petitioner have come before the honorable court. Karnataka Municipal Act provides for filing suits under section 284 of the Karnataka Municipalities Act, and also provides for obtaining injunction without issuance of notice, and same is not arrayed because of following reasons. Now, the reason is, Lord, the so-called reason is that there is a collusion between the municipality and one of the parties. Now, that is all the more reason why you should file a suit. You make him a party. Whoever is colluding with whomsoever, make him a party, file a suit. You know that 284 exists. You write two things. You say, I have already gone and filed a suit. But this case, I don't want to file a suit. For following reasons, I did not interrupt, Lord. I will not continue arguing. In the present case, since the property belongs to second respondent, petitioner will have to seek declaratory relief, building being put so and so, so and so. Now, when the statute provides for a remedy, you don't avail it. And you say you have filed a suit. Why did you file a suit? Then you should have filed that suit also as a writ petition. First submission. Second submission is, kindly see the prayer. Page 39. Issue a writ of certiorari or any other appropriate writ. Against what? Nothing. Declare that action of first respondent in allowing construction or so and so without obtaining a license is illegal. No, I obtained a license now. If you are aggrieved by my obtaining of the license and constructing it, who challenge it in the suit that you have filed or file a fresh suit? Lord, you cannot convert a writ
against the order granting license.
284, Lord. That's what he says. Suit can be filed, and also, Lord, no, that he agrees one alternative remedy is according to him is an alternative remedy. Lordship, I need not discover and find. According to him, that is an alternative remedy. And secondly, Lord, his entire case was that I have not obtained a license. I should obtain a license and construct. I have obtained a license. Now, if the license is bad in law, or if I violated the license, this is a question of facts. Now, any amount of court commissioner can be appointed, any commissioner can be appointed. We will only be troubling your lordships and harassing this honorable court with facts that I am right, he is right, there is encroachment, there is a suit. So therefore, Lord, whoever is aggrieved, if I were in my learned senior friend's position, I would have gone and educated in the civil court. And now third point is, now he has not sought a prayer for demolition. He finds fault with the court in not demolishing the law. I have not sought a prayer. I want the honorable court to demolish it. Even without a prayer, even without there being a prayer, travel beyond my prayer and grant. And that is the wrong, that is the error apparent on that is not the ground for challenge. No. That's all. And all rest of it, Lord, I want to. We can always not trouble your lordships in showing that who is right, who is wrong in this fact finding authority. We should not trouble your lordships. My conscience pricks. If he files not a suit, I will go and trouble him rather than others.
Yes, my submission is, so far as the prayer made in the writ petition, it was still at the beginning stage. I said, issue a writ of prohibition restraining the respondent from putting up construction in any portion of the property described in the writ. It was at the beginning stage. I came here on 29th of June and obtained an order stay after showing that there is a gross violation of the municipal law. And even the learned single judge has agreed. He has not spared them so far as the legality of the construction is concerned. Therefore, my submission is they are liable to demolish the construction now made.
Yes. Sorry, one other point. Sorry, I'm very brief. More than that's all.
Thank you, Mr.
6, just one more minute. One more minute. I read from last 7-8 lines in para 6. Just I'll read one more paragraph and I'll read it. One more line and I'll read it. From the middle of that, para 6, the said Raghavendra Naik, the said so and so appears to be president of the trust. Nursing home is situated in so and so road. From Chhatradakeri, which is a municipal road, from the western side, eastern side, a small lane runs into the nursing home, which is not a municipal road. His idea is why he has filed this writ petition also writ appeal. My contention is it is municipal road. That even if there is a setback or whatever, there is an open lane which belongs to the municipal corporation. By filing this writ petition, he wants to claim or stake claim over that property and say that the suit is pending there. He has filed an injunction suit. In the division bench or in writ petition, he gets an order saying that there is a setback violation. That land belongs to me. All these contentions are being made just to take away that property from the municipal corporation. And therefore, Lord, if I compromise this, if I go and compromise with him saying that I have a setback violation, you condone, I will say that the land also belongs to you. We both would have knocked out the property from the municipal corporation. This is the actual situation. I am saying it with all responsibility. The road belongs to the corporation, municipality. He says that is my road.
We don't know who wrote it.
Yes.
We don't
All that is immaterial. I'm just
Not raised in
not raised. And we will not go into this question. The scope is only confined to examining the order.
Yes. I'm just saying, Lord, what is the
why you should what
is the inarticulate major premise
we don't.
behind this?
So we will not decide this question which is being raised.
Yes, sir.
Not this. Thank you.
So far as alternate remedy is concerned, if for some reason this one court that you have alternate remedy and you have not sought it, my first reply would be that it was filed and an interim order was obtained. This petition was accepted by the Honorable Court and a final order was granted. The courts have held once you admit a petition and thereafter decide the case, question of alternate remedy does not arise. Even then, if this court holds that there is alternate remedy, then other remedy should be kept.
Okay. Thank you.
Relevant.
Hey, Mr. This will go on like this. You should conclude at one go. You will say something, then again he will respond. Thank you. Yes. This take recourse to such remedy 184, right? 284. Yes. If the question is being passed in violation of some provision, such a should raise. Contesting this writ of you should challenge that order. What is there but yes. What affidavit?
The husband has filed a petition for divorce. The ground of purity the judge. But the ground of purity not the decree was granted. Not the continuously not wherever was taken place within a matter of 1 month, 1 month, he went up, he is not ready to reach the judge. And the ground of monarchy is important. And it is not going to work. So this group of monarchy went up because he is not interested to get married as this petitioner, the husband. Because of her mother's spouse, monarchy got married. And within a matter of 1 week, she went off. And even after several demands, she did not come back. And she demanded money. Even for that also, monarchy agreed as for their demand. And then it was the Kosa monarchy increasing. And she was working on the therefore, she is not ready to come from the husband. Then ultimately, was maintenance file that was dismissed. That has been challenged. That is also dismissed. Then ultimately, the final rate was signed by the husband. That is, he is not ready to come back. Then divorce petition was filed. On the ground of purity, several criminal cases was filed. Kept it filed against the parents as well as the husband. And also, she has filed the issue given influence to the media to
what are you doing? I mean, it's her opinion. She has to argue, right?
State government, those who wanted to take time, several times. Several times.
By direction, you are at liberty.
By
direction. No permission is necessary, madam. As per the judgment, you can file it. Who is preventing you? File it.
The timing, you must have fixed the date, in fact, that has been refused by the trial court because we did not file any application even on 25.
No, wrong means your claim for maintenance has been allowed.
No.
What did he say? Your claim for maintenance has been turned down. That's what you said, right?
The court has refused.
Not made
it. Refused to give maintenance.
Yes, not made a claim.
She has made a separate petition file.
That's the
that has been dismissed. This petition last has not claimed.
Also, she has not done any maintenance here. So I would like to adjudicate that for any adjudication of the matter.
You file whatever you are.
No, it is posted for the they didn't file any application. Even before the
claim for maintenance in this application. Where is your application, madam, in this appeal seeking maintenance? Then
Huh?
And because of the alimony has also been dismissed by the trial court.
Dismissed.
Granting of decree, your lordship. So that's why I will appeal your lordship.
But she has not filed an application at all. Nobody will find it.
The observation, no such application is filed.
Application is not necessary.
I understand.
Yes, under section 25, court is at liberty to file.
Liberty.
No, no application is necessary.
No, supposing if she, in any case, we don't know what we will, but she is entitled to, I mean, in case of dissolution of parish, she is entitled to permanent elimination.
Yes,
There has to be some material before we.
As it is said, the court is entitled to permanent already. When she is not doing the work. She is earning. She is an employee.
You don't know, you say all that in your affidavit, right? File it within a week.
That is there observed in the order also. That is there in the order. Because of that reason, not they have challenged it. Not because of divorce. It's only permanent already they have challenged.
Hey, Mister, you should at least be clear on facts, right? Parties on basic facts. I mean, you are saying one thing, she's saying, you should be clear, right? You don't dispute this proposition that once the court is dealing with the issue of dissolution, the court can grant permanent alimony. So for that purpose, there has to be material on record, no? How will we decide the question of permanent alimony, supposing if our appeal has to be dismissed? And so then if you don't want to file it, we will draw an adverse inference, later file.
My suggestion is that even before the trial court, in the divorce petition, she has not claimed at all for permanent alumni. And what is observed, since he is working, permanent alumni is not necessary. By observing
All right, it's your choice, Mr. Whatever you want to do. If you don't file an affidavit, we will draw an adverse inference. Her affidavit about your income and everything will be believed. We don't know. We are giving you a week's time. If you are at liberty to file an affidavit. If you don't want to fight, don't fight. Argue. We will decide it, whatever. We can't make you follow the law, right? If you are not complying with the directions of Supreme Court, if you don't comply, we will pass an order. We will decide, don't do it. Let her file an affidavit. You don't file. You advise your client not to file an affidavit. We will deal with it. Yes, that's why. That's what we are telling you. Let her file an affidavit. You don't file an affidavit. We decide it.
I will file my objection to that.
You must be knowing what Supreme Court says, right? You know that, no? So take action. If you don't decide, file an affidavit. We will decide it. We have told you. It is open for you. We can't compel you to file an affidavit, right? Fine.
Whether you want to file objections or whether you want to file an affidavit, you decide.
You decide what you have to do.
She is asking to file an affidavit. Date by kindly please to her.
Date, of course. Which date? 8th April. 8th April. You seem to be in a hurry, right? Everybody should be like you. See, 2011 appeals people seek adjournment, and in 2018 you are so eager to argue. Right now you want a decree. Marriage season has begun, right, Mr. Presents learned counsel for the applicant. Prays for short adjournment in order to enable him to file an affidavit. Assets and liabilities. It is open for learned counsel for respondent to file an affidavit if so advised. Fine. List on 8th April 2022. Which is this 60?
Lord, I appear for the petitioner, my lord.
Master.
Tomorrow. 20 minutes. Yes. Which case?
My lord, 67, my lord. I am appearing for the petitioner.
What?
In ethics, the Abhishek Malikwadi, government advocate.
Yes.
My lord, this is a case.
No, counsel for respondents are not there.
Please,
But password.
Password. Number 68.
We are appearing for the contesting respondents, my lord.
Ready?
Yes, my lord.
Please continue tomorrow, madam. It will not be possible to conclude it within 20 minutes. Tomorrow it will continue with this. Yes, next.
Much obliged.
69, the Satish case, the Nishan David, the DF Sanjeev.
In both the cases. Both the cases. Yes. Can we conclude it? Then we will begin. Not possible. Let it remain there.
My lords, there is some urgency, my lords.
Fine. Tomorrow.
Tomorrow. My lords,
Why Monday?
My lords,
we don't know how many cases are listed.
My lords, may kindly see the order dated 13th of December 2021. Matter was specifically fixed for this hearing on 4th of January. There is some urgency.
1st of January?
4th of January.
4th of January. Correct, tomorrow. What is it? Hey, you are senior, right? Not senior. We'll consider it next full court meeting, right? Furnish your particulars. We'll make you senior so that you stop seeking adjournment. Fine. Okay.
Number 17.
Here with appellant, my lord.
I am for the respondent.
Yes.
Can I come in, Lord?
Of course. Why not? So how much time will you take, mister?
My lord, I will take about half an hour, my lord.
Oh, why you are told that he is not a workman, right?
Yes.
He is a manager, not a workman. Therefore, there is no need of remand, right? Correct?
Yes, my lord.
Kasturi.
Yes, my lord. Yes.
That's the case.
Yes, my lord. Shall I start, my lord?
Please.
The lordship may kindly see, my lord, page number 257 of the paper book, which is exhibit W1 in the labor court 257. Is the application. He describes himself when he applies for the post, his profile. In the heading, your lordship will kindly see after his name and address, head sales operations, recognized consistently, exceeding performance is his application. This is exhibit W1 before the labor court. Then, my lord, the order of reference your lordship may have a look at. I would seek the help of my lord, Justice Vishudhya. Here the court, because it's in Canada, I don't, the award, it is extracted. Whether he proves himself to be a workman.
Of reference, you are
Column 2, yes, Anvaya, Karmika, Paribhashana.
Which page?
Page 183. I'm sorry, my lord, I didn't give the page. This is in Kannada, it is extracted by the labor court in the award. Whether he comes within the meaning of section 2 yes of the ID Act. Normally, the government has to form an opinion, prima facie, as held by the Supreme Court 1953, State of Madras versus C.P. Saradi, that here he is a workman, there you refer the matter. You make a prima facie view. I may go and contest saying he is not a workman. But the government can't say whether he is a workman or not, you decide. It must get jurisdiction to refer a matter. It must form an opinion, prima facie. It does not. It simply says whether he comes under the definition of Section 2 just as the ID Act. The Labour Court in its award says at paragraph 10 of the award, at page 190, in regard to workman issue, there is no pleading in the claim statement that he is coming under the definition of workman. He has pleaded in detail regarding appointment, nature of work performed by him during the course of employment, and also work performed by him in previous employment. It is also alleged that without reviewing his performance was shown very poor. So there are no specific pleading on behalf of the first party in his claim statement how he has come under the definition of workman as defined in Section 2(s) of the Industrial Disputes Act. In this regard, my lord, I rely on a judgment of the Supreme Court in Britannia Biscuits Company's case, where the Supreme Court said if there is no pleading, the question of pleading any amount of evidence does not come at all to the aid of the party. I will refer to the judgment later. Now, your lordship may kindly have a look at page number 87 of the paper book. What we have pleaded before the Labour Court at paragraph 4. The second party submitted the first party was appointed as a senior sales manager sales. The first party's job profile is attached herewith as Annexure C. It is clear from his job profile that he was accountable for ensuring and achieving sales targets of voice and data products and for providing appropriate and efficacious solutions to government, public sector, etc. Then, my lord, in the just below the at the end of the paragraph, it says Mr. A.S. Raghavendra was handling a team of 3 employees who themselves were managerial cadre and were reporting to him and could by no stretch of imagination be classified as workmen. The list of employees of his team and their designations are annexed as Annexure D. This is one of the averments made by the company before the Labour Court. Then, my lord, we have specifically said at the end of the page that he is not a workman under the ID Act. Then, my lord, your lordship will kindly have a look at page 197. This is the order of the Labour Court, 197, at the end of the paragraph, just about 4 or 5 lines above. I'll read this note. To substantiate the second party management has given again produce executive M and the appointment letter dated 22/6/2009. A separate discussion is also made on the with regard to clauses in the appointment order, Annexure A attached to the appointment order, the appointment letter produced by second party management, that he was eligible for HRA, CCA, 50% basic salary, special allowance actuals as opted for car hiring charges, petrol, and maintenance of driver salary as per the company's hire policy, medical reimbursement up to 15,000 rupees per annum, leave travel assistance, etc., membership credit card reimbursement as opted for, mediclaim insurance, superannuation as per company's policy, and attached appointment order clearly demonstrates that the first party was provided car facility, car driver as required by the managerial post, to be the above, in view of the above reason. Sorry, Miller. First party was not only working senior manager, but also was doing the job of a manager. Therefore, my lord, these are not the facilities given to a worker under the ID Act if he is joined as a worker. Now, my lord, if your lordship will kindly have a look at page number 64, the Honorable Single Judge has gone on the premise that were described in one of the documents as a worker. Now kindly see page 64, one of the computer outputs, employee's name, annexure C it is, yes, Raghavendra, employee number is 61605. It is not as if one place somewhere it occurs worker number of the worker's number in one document. That doesn't mean he becomes a worker. That is the premise on which the Honorable Court has gone about. He is Exhibit 2 in the inquiry in the Labour Court. Workers' evidence, W221. Now, my lord, your lordship will kindly have a look. The number is mentioned 6105. That is a number on which the court has also relied. Now, kindly see page 56. The appointment letter is mentioned at page 56. Appointment as senior manager B2, sales in Bharti Airtel Limited, in terms and conditions of your appointment as follows. Salary about 22 lakhs, 2.1. Kindly go to paragraph 5.5 at 59. Being a managerial cadre employee, you will be responsible for overall smooth and effective functioning of the department, establishment, office staff, employees under your charge, and be directly responsible for the successful and timely completion of any job, work assigned to you or any person working under you, under your control and supervision, and from under within the department, establishment which you are for the time being in charge, taking charge, holding the charge. You would adhere to the norms of the discipline. You will also be responsible for the ensure proper and effective adherence to norms and office discipline, including working hours, systems, procedure, etc., etc. And employees working under you, supervision under the department, office, establishment under your charge. These are the responsibilities given to him. He is the head of the sales. He applies for a job and joins us. And now he says he has become a workman. Now you kindly, Miller, the page number 280. Your lordship may have a look at page number 280. It's one of the emails. He himself writes at page number 280, my lord. Paragraph 5.2. Yes, Raghavendra's response. Information Technology Minister and Sales Director, executives, etc. Irrespective of the fact whether they have people reporting to them, they have an individual role without anyone reporting to them. Then kindly see 3. The above mentioned 3 members as claimed by Bharti Airtel, that is, I said 3 employees were reporting to him, managers. That they were reporting to me were called also as managers with any kind of managerial powers and duties. In simple terms, they are frontline sales representatives designated as managers for the purpose of business or convenience of Bharti Airtel Limited, as it was in my case. This is perhaps intentionally done with view to authority so that acts as a defense at a later stage, etc., etc. Now, your lordship may kindly see what is the persons who is reporting to him are not managers. They don't have managerial powers, he says. That means at least somebody is reporting to him. He is not a worker. If he is a worker, nobody will be reporting to him, and 3 people won't come work under him. Now, kindly see, my lord, the allegation that the resignation was under coercion is made after 1.5 years. Kindly see page 89. We have taken that plea at paragraph 8. If he was under coercion, he would have immediately done so by raising a dispute. The government, their first party, is still unable to secure an aspirational job till page 89, para 8 blood. Only goes to expose his lack of requisite competence and skills and having failed to secure an employment till date. The further allegation that the first party now chooses to allege is that is due to lack of favorable feedback during the referral check, which did not only is unsubstantiated, but also a decadent allegation against the management. Also, the factum of approaching this honorable court with his frivolous complaint nearly 1.5 years after tendering his resignation and receiving his full and final settlement clearly establishes that his resignation was his own free will and volition, not out of coercion. Now, my lord, kindly see, a person makes, if he is a workman, there is a provision under the Industrial Disputes Karnataka Amendment, section 10(4) capital A, under which he can immediately go and file a petition. There is no need to go to government for a reference. He keeps quiet for 1.5 years. Now he goes to the court and says, goes to the government, I am a workman, please refer to the matter. They refer in a very haphazard manner that he is a workman or not himself, because the government is not sure whether he is a workman or not. Therefore, they refer the matter. Can it be allowed, my lord, to say that he is under coercion?
Yeah.
Now, my lord, kindly see, one more aspect of the matter is page 138. It is one of the documents of another employee manager, Sujat Kumar, 138, annexure J, typed copy of the computer output. 138, my lord. Employee name Sujat Kumar, employee number so and so, email address, etc. Assessing manager Mrs. A.S. Raghavendra. He is the person who is assessing another manager, an employee, an officer of the company. Still, the High Court, the Honorable Single Judge says, no. You are described him as a worker in your number. You are given, therefore, he is assessing manager. He is not a managerial staff. Now, my lord, there is one aspect of the matter your lordship will kindly see, that this employee had served a notice on the company and had worked the notice period. That was, my lord, for about 45 days he has worked during the notice period. That your lordship will get, my lord, just 1 second. That is no dispute that he has worked for one notice period of 46 days. He could have withdrawn the resignation during the notice period. Then the ball is in my court to terminate. He resigns. My lord, there is, your lordships are aware that there are in a large number of cases the Supreme Court has said that he can
withdraw before it is accepted. Before the resignation is accepted, he can withdraw.
Of course. No, not even resignation. During the notice period, he can withdraw. That is Srikantaya, BML, Supreme Court.
Yes.
And then Swarnakar, the judgment which reviewed all these judgments. Now kindly see page 67, my lord. Though he complies under I'm representing under compulsion, etc., that's a different matter. He had a notice period. 92 days notice period. 47 days he has worked, page 68. He could have withdrawn the resignation and said, I am sorry, I'm not going to leave your job. I could not have done anything. I have to tell him, I am terminating your services, I am not accepting your notice period, whatever it is, what notice you are given, etc. That's a different matter. The intention behind it was not clearly he could have withdrawn the resignation if it was under coercion. He resigns because he was found inefficient, perhaps. He may not be inefficient, we don't know. Now, this aspect of the matter was not considered by the Honorable Court. Then your Lordship will kindly see page 106. 106. At paragraph 13, he says in his evidence, I state that I was disrespected, disregarded, irrespective of my employment status. My lord, a worker will not come and write like this saying, my status was disrespected. I am a senior sales executive. See, otherwise he will not say like this in his evidence. Then, my lord, kindly have a look at one more aspect of the matter. That is, the Labour Court holds on examination of all these facts that he is not a workman, having regard to the various duties and the responsibilities he had. That, my lord, is a finding specifically given by the Labour Court on assessment of all these aspects. Paragraph 14 of the award at page 1 number 193 and 194. Paragraph 14, 193, my lord, page 193. In the cross-examination, the first party admits that he in the year 1992 had worked in steering resorts group as a sales manager. Thereafter, he worked in Kodak India for 2 years as regional manager for 4 states of Karnataka, Tamil Nadu, Andhra Pradesh, Kerala. Thereafter, he joined Bharat Airtel as a senior manager. His last day of working was on 9/5/2011 as a senior manager. He was looking after South states, Karnataka, Tamil Nadu, Andhra Pradesh, and Kerala. He was working in these states. In 2011, his annual package was 22 lakhs. But he stated that nobody was working under him. He was looking after the work of the central government regarding machine tool made projects, Bharat Airtel. He further stated in his comment that he powers a senior manager, but he pleads that their job profile is not given, but appointment order is issued. He has denied that this manager working under him. He specifically stated that he was working as sales manager and is not coming under the definition of workman, and he submitted resignation to the company unwillingly. Well, my submission to your lordship is, based on these facts, at paragraph 16, the court comes to the conclusion he is not a workman. The Honorable Single Judge, in the order, my lord, kindly have a look at it. There was enough material before the Labour Court. The Honorable Single Judge says, after referring to various case laws, my lord, just 1 second, just give me 1 second, my lord. After quoting the
continue tomorrow, Mr. Kasturi. Tomorrow.
Very well, your lordship, please.
Further hearing.
Very much obliged.
I'm sorry to mention that item 56, which is came back.
Tomorrow it will come up.
It will come tomorrow minutes?
Yes.
Grateful.
Huh? Which case?
Who is appearing? You are appearing. So, yes.
No objections to this
Next
next
week.
week. I have only one issue. I want to adjudicate when the matters have already been admitted by this court. If this honorable court is seized of the matter, then I get the notice for
Oh. Hey, Mr. Jeevan, yes, how can this? Hey, you at one time, one hand you are seeking adjournment, other hand, not aware. No, please, so all right. So instruct the authorities, Mr. Gandhi, it's your mistake.
specifically
Which case?
writ appeal is pending, might not be connected matter.
No.
Serial 63.
No, what is the number, Mr.? Which case?
63.
63, madam. Yes. Mr. Please instruct me. Mr. Jeevan J. Nirarki, counsel for respondent praise for short accommodation. Next week, what date, Mr.?
8th is also.
8th April. 8th April 2020.
It can be instructed, my lord.
We have told him, Mr. He should not be required to make a mention before us. Right?
Yes.
71. All right. Monday is what? 4th April. 71. 71. Monday. Laureate counsel, senior counsel for the appellant. Praise for adjournment. List on 4th April 2022. Yes.
In the excise duty and FCD matters which are listed on Friday afternoon, Friday manner, we be permitted to circulate the written submissions we had undertaken before the court that we'll find the written submissions in advance.
Okay. Have you supplied a copy to the other side? Okay. We'll see on that day. Yes, let them. Is the later half of the day only? Yes, around 2:30. Let's see. You have supplied a copy to the other side, right? Hearing cases tomorrow. Case will further hearing.
Survey case access are here.
ಮೇಡಮ್ ಗ್ರೀನ್ ಶೀಟ್ ಮಾಡ್ಕೊಳ್ತೀರಾ ಹೆಂಗೆ ಗ್ರೀನ್ ಶೀಟ್ ಮಾಡಿ